Yes.
Lordship, I would like to mention unlisted matter, criminal petition number 193 oblique 2025. Lordship, as per previous order dated 7/11/25, the matter is supposed to be listed after 3 weeks, but matter has not been taken up till date. So, Your Honor, I may be allowed to take up matter tomorrow. Lordship.
Next week. Tomorrow it will be difficult. A lot of matters.
Lordship, instant matter is raising before a trial court in 18th of this month. So, interim order have not been allowed.
Correct. Next week in the next week Monday. Monday it will be listed.
Oblige.
Monday.
Your Lordship, I beg to mention item number 8.
Item number 8. Yes.
Your Lordship, I have taken consent from the other party.
Huh.
Your Lordship, matter may be exoned. It may be taken up after 4 weeks.
You are Mr.
M. Kamcham.
M?
Lordship, M. Kamcham. My name is not there in the course list.
You are mentioning on behalf of whom?
On behalf of Senior Counsel Ansuman Sani.
Anshuman?
Sani.
His name is not there.
Yes.
Anshuman Sharma?
Ansuman Sani.
Sani?
Yes.
But his name is not there in the cause list.
Yes, Your Lordship, he is from counsel from another state.
He's a senior counsel.
Not senior counsel, Your Lordship.
Then his name is not there.
Your Lordship, I'll make arrangement with the registry to reflect his name in the course list. Your Lordship.
He has signed a wakalatnama.
Yes, Your Lordship.
Marto, Kato, then Nayali, Sora, all these people are not there.
Your Lordship.
They are respondent, Lordship.
Khoda Tama.
His name is reflected, but he's not taking up the case, Lordship. The counsel has been changed, Lordship.
Also has been changed.
Yes, Lordship.
On the prayer of Mr.
M. Kamcham.
M. Counsel, with the consent of the other side, let the matter be listed after the ensuing vacation.
Lordship. Obliged, Lordship.
Obliged.
I would like to mention item number 5, 6, and 7, Lordship.
5, 6, and 7.
Yes.
Yes.
Maybe after break. 6 after break.
After
break.
vacation. You are Mr. Aki.
T. Tapak.
Mr. T. Tapak, the learned counsel, appearing for the petitioner, submits that the matter may be taken up after the ensuing vacation.
Okay.
He has informed the other side.
Yes.
No, Your Lordship, I'm for state.
You are for
He
the
has not
side?
informed me.
And Jyoti Jonglu.
I have informed.
Okay. It is submitted that he has already informed the other side. Let the matter be listed after the ensuing vacation.
Obliged.
Yes.
Your Lordship, I'd like to mention item number 11.
Item number 11.
Yes.
Yes. You are Mr.
I'm for the petitioner, Mr. M. Khambo.
You are for the petitioner.
Yes.
Well, I'm appearing for one set of respondents, my lord.
Okay. Yes.
Well,
He's
Well, there is a direction from the Honorable Court to prepare paper book. And I am
Yes.
told paper book has been prepared and served on one of the counsel, Mr. Tama, my learned friend, Mr. Tama. He has been served with a copy of the paper book. But so far as the party whom I am representing, along with my friend, Mr. Deuri there, the paper book possibly has not been served on us.
Okay, you served the paper book.
No, it has been prepared by the
paper book,
registry, my lord. Registry,
It has to be, yes, registry has to serve it.
my lord.
Okay, well, I'll pass an order.
Your Lordship, paper book has been already prepared.
Paper
Yes.
book is prepared.
Yes, it
What
is.
the senior counsel is submitting that he has not received it.
Your Lordship, we can,
The registry will serve, registry.
Yes,
again
registry will serve, my lord, yes. My
And
lord,
the player
can it be fixed in the first week of January, my lord?
First week of January.
Your Lordship, I have an instruction that earlier consent was taken and the matter was fixed for 22 December. That was
22
fixed.
December.
Yes.
22nd December, Mr. Majumdar. Is it possible for you?
I have got some personal work, so my lord, December it will not be possible. Let it be in the first week of January, my lord, 7th of January.
The first week of January, because
Matter of few days only, my lord, yes. After the
principal
vacation
bench is
also
having a
comes.
vacation.
my lord.
Correct. Principal.
And my
principal
lord, this
petitioner-
matter will take some time. Earlier, the matter was heard for hours together, could not be disposed of. So it's a longish matter, man.
Okay. So we'll fix it in the month of January, first week, 7th of January.
My lord, my lord.
7th of, okay. Mr. So-and-so, the learned counsel appearing for the petitioner submits that this matter may be taken up in the,
Your Lordship, with due respect, kindly can it be in other date other than 7 in the first week?
other
Because-
than 7.
Yes, other than 7.
Other than 7, Mr. Majumdar?
My lord,
Six.
6th and 8th, there are some difficulties, my lord.
Yes.
7th is the only date I can, otherwise it will go to first week of February because last 2 weeks, my lord, I've got some personal work at home, so I'll not be able to attend court, even in Guwahati.
Okay.
First week of February,
First week of February.
my
First
lord,
week
my
of
lord.
February. First week of February, we'll
Your
fix it
Lordship,
on, fix it on 2nd.
it will be too
My lord,
long
my
for
lord.
us. First week of January, it will be too long for us.
Hmm?
Kindly on mid of January.
Mid of January, he has some difficulties.
Vacation is
The vacation is
Vacation is
there.
there.
before 19.
Yes.
Before 19, any day, Your Lordship.
There are holidays, my lord.
Yes,
From-
they are in the principal city.
Yeah. From 10 to 16, there are holidays.
Correct, correct.
Second, my lord, 2nd February.
2nd February, we'll fix it. 2nd February.
My lord, my lord.
2nd
Ma'am.
February. Mr. So-and-so, learned counsel appearing for the petitioner submits that a matter should be adjourned and listed in the last week of December. However, Mr. Majumdar, the learned senior counsel appearing for the respondent submits that he has some difficulties, more difficulties on that particular date, and therefore he prays that it should be listed in the first week of February. Accordingly, the matter.
Your Lordship, fix date may be
accordingly-
given kindly. Fix date may
Yes.
be given.
Accordingly, on agreement amongst the council, let the matter be fixed on 2nd of February. 2nd of
My
February.
lord, my lord. Deeply obliged.
May I please, Lordship?
Yes,
I beg to mention item number 25.
25.
Yes.
Yes,
Lordship, here I am for respondent number 2 and 3.
okay.
Conducting council, Tijamo, extending council of food and civil supply. He is unable today due to some health issue.
Government council,
Yes.
Mr. Singh,
Madam, I am appealing
You are
for
appealing for?
respondent number 6, 7 and 8, FCI respondent, madam.
6, 7 and 8.
Yes.
Okay. So he is seeking for some reason. When do you want it?
Madam, after 4 weeks, madam.
After 4 weeks.
Yes.
Mr. So-and-so, the learned counsel.
My lord, one small prayer. Extending council, Tijamo name should be reflected in call list.
Mr. T
Tijamo,
Jamo for respondent number
2 and 3.
2 and 3. Mr. So-and-so, the learned counsel appearing for Mr. T Jamo, the standing counsel.
Yes.
Standing counsel appearing for respondent number 2 and 3 submits that Mr. Jamo has some problem today, so he could not appear before the court. He submits that the matter should be listed after 4 weeks.
4 weeks.
After 4 weeks. Mr. B.K. Singh, the learned counsel appearing for respondent number 6, 7 and 8. 6, 7 and 8 doesn't object to such prayer. Have you intimated the counsel for petitioners?
Yes.
You have intimated,
Yes, your lordship.
you have taken the consent.
Yes, yes.
Doesn't have any problem. Let the matter be fixed in the first week of January.
Well, after view vacation, madam.
Let the matter be fixed in the
4th week.
in the 4th week of January. The learned counsel for the respondent number, the learned counsel appearing for the respondent number 2, 3 has submitted that he has already intimated and taken consent from the counsel appearing for the petitioners. Let the matter be fixed in the 4th week of January.
And your
4th week of January.
lordship, I beg to mention item number 16, lordship.
16,
Yes, lordship, in order column, lordship.
yes.
Lordship here, as instructed by the J. Sering, lordship.
1 second, that the name of the name of the council for respondent number 2 and 3 should be reflected in the council list. Yes.
Lordship, on behalf of Jay Sering, Lordship. Lordship, the Jay Sering, he wants to withdraw criminal, IA criminal 15/2025, Lordship. He wants to withdraw this IA, Lordship.
But he is not there. Your name is not there in the council
Yes,
list.
Lordship, on behalf of Jay Sering, he is keeping not unwell, Lordship, today. So, Lordship, he instructed me to withdraw, Lordship, this IA 15, Lordship.
Only the IA.
Yes, Lordship. This is suspension of sentence, Lordship.
You are Mr.
G. Jine, Lordship.
Mr. J. Ines, the learned counsel appearing on behalf of J. Serinki submits that on instruction from J. Serinki, he wishes, J. Serinki wishes to withdraw the IA in bracket criminal stroke 112 stroke 2025.
IA 15, Lordship. 15 of 2025.
IA 15, okay,
Yes,
IA
he
15
wants
of
to withdraw
2025. Prayer is allowed. IA criminal stroke 15/2025 is dismissed as withdrawn.
Yes, Lordship. After
Let
Lordship,
let the connected criminal appeal be listed after the ensuing vacation.
Obliged.
Mr. T. is present on behalf of the state.
Then the for the
Learned
victim,
APP, huh?
POXO matter.
Ete and your name?
Oh, Bingi.
Oh, over here for the victim present, huh? Just give their presence.
Obliged.
Obliged, madam.
Item number 1,
May I please, my lord?
Yes.
Lordship, this is successive bail application.
Hmm?
Successive bail application charges under 74, 75, 78, and 79 BNS. Read with section 12 FOXO.
So we'll issue notice on this. POXO is there.
Yes, my lord.
Heard Mr. So
Vitamin.
the learned counsel appearing for the accused applicant also heard Mr. L. Hage, MS L. Hage, the learned APP for the state. This is an application under section 4833 of BNSS 2023, praying for release of the accused applicant on bail in connection with Deporizo Police Station case number 48/2025, corresponding to BSR/POXO case number 07/25 under sections 75 in bracket 2 bracket 3/74/78/79 of BNS 2023, read with section 12 of POXO Act 2012. Issue notice on respondent number 2. Respondent number 2 and 3 through the registry as per the prevailing notification issued by the government, issued by the High Court, Guwahati High Court. Notice to respondent number 1 is dispensed please as the learned APP enters appearance on behalf of the state. Call for the case diary.
Lordship, trial already started, Lordship.
What else?
Scan copy of the TCR.
Scan
report.
copy of the TCR, the registry to call for the scan copy of the TCR from which court?
From the Lordship, but special judge Foxo Basar Lordship, Leprador district.
Special POXO court.
Otherwise, my lord, since here in this applications, I am not on the merit, rather for the non-compliance of procedure under
No,
47.
correct, but
section
still, I mean, still that has to be there. I mean, the record has to come. They will have to produce the record whether there is compliance or non-compliance.
Yes, my lord.
So from the court of so and so in connection with what was the POXO case?
12 of Lordship. Connection with Lordship. 7/2007, 75/3, 74.
No. I mean POXO case.
POXO 12, Lordship.
Hmm?
Uh,
No. In connection, we read in connection with Deporezo police station case now
4825, Lordship.
Let the matter be listed after the ensuing vacation.
My lord, since I've
Or
already
let the matter be listed on listed on 20 listed on
18, my lord.
listed on
18.
18. Yes, 18.
Obliged, Lordship.
Item number 2.
Obliged.
May it please yours.
Yes.
Lordship, apprehending arrest, I'm here before your lordship. The FIR is as page number 18.
Yes.
The names are there,
Names are there. Which are the names?
only serial number 5.
You're coming for one.
Yes, serial number 5.
Serial number 5. Yes.
Yes.
What is the allegation?
The allegation is that there is a lordship, as per the FIR, stolen of vehicles from Delhi, Gurgaon, Haryana, and those vehicles are sold here at Arunachal Pradesh and Assam. So altogether 61 vehicles were recovered.
How many vehicles?
61 vehicles.
61 vehicles.
Yes. So one of the vehicle is the white color Toyota Fortuner, was under my possession. Now, lordship, kindly come to
Number 6.
number 5.
Number 6.
Number 5.
Number 6, page number 19.
Page number 18.
19 regarding the allegation, especially.
No. I mean, page number 19 is the allegation, right?
Yes,
Yes,
Number
allegation.
serial number 6.
Yes.
Serial number 6.
But your name is there in serial number 5.
Yes.
So and so RC Toyota Fortuner so and so.
Yes.
Yes,
Now kindly come to page number 24.
24.
Yes.
Yes.
The said vehicle is in the name of one Miss Anita Lego.
Hmm.
Now, lordship, come to again page number 21.
Page number
21.
21.
This is the sale deed.
Hmm?
This is the sale deed.
21 is the sale deed.
Yes. By the owner selling to the company MS Ocho Construction.
It was sold by Anita Lego.
Yes.
To whom?
To the company MS Ocho Construction.
MS
Ocho Construction.
Ocho Construction.
Yes. Now, lordship, next page. Page number-
Proprietary is somebody else.
Yes, lordship. Now, come to page number 22.
Yes.
This is my ID card.
Hmm.
I am the manager
Hmm.
of the company KCC, Kengia Construction Company. And this company, Ocho Construction
Then
Company,
how come this identity card was been issued by TRIMS?
because the petitioner was the manager of the construction company and they were having construction of medical college that time.
But how can it be issued by TRIMS Medical College?
Because he has to enter the premises for that.
No, this is not a valid identity card. Enterprise. This is
It's a-
temporary
yeah.
identity card.
Yes, lordship, it's a temporary card.
Temporary identity card only for
Yes.
coming and going of the thing.
Yes. So I am the manager of the company. And this Ocho Construction company is the sister concern of our company. So I was only having the possession of the vehicle.
How do you say that like this also is like your sister concern?
Statement is there. Statement is there.
The statement will not do. I mean, you bring in some. I mean, how do you? If there are two companies, how can you say that two companies are sister companies? There has to be some material on
It
this.
is their lordship. But the vehicle is I am not the owner of the vehicle. I have not purchased the vehicle. I was only having the possession of the vehicle given by the company. And lordship, moreover, the allegation is that only I have been the possession. I have given the vehicle to the police.
But as
It was seized.
as per the allegation, this vehicle was involved in an accident. I mean, in a case of dacoity,
Yes, that is there. That
in a
is the
case in
allegation
dacoity,
in Gurgaon, Lordship.
correct?
Yes. So I am not the owner of the vehicle. And moreover, Lordship, if Lordship comes to page number 33,
33.
yes, there's a bail order.
Hmm.
The bail was given to the one of the person who has purchased two number of vehicles. He was the purchaser, even though he was granted bail. I have already given my statement before the police. Now my apprehension is at paragraph 7 and 8. Why I'm apprehending? Paragraph 7 and 8. Paragraph 7, Lordship, that despite such full cooperation by the applicant, I was called by the IO, my statements were recorded, and after some time, for the past few days, some police personnel in civil dress have been visiting the applicant's residence and informally asking his family members to send the applicant appear before inquiry officer, investigating officer again, which has created genuine and reasonable apprehension. And further, paragraph 8. Lordship, I have already given my statement. I was called.
When did you give it?
Lordship, it is the notice is of.
After receipt of the notice.
Yes.
Where is the notice?
Page number 20.
Then a statement, your statement.
Statement is with the police, Lordship.
No, your statement in your pleadings in the application that you have gone there on such and such date and your statements have been recorded. Where?
Paragraph 4.
Huh?
Paragraph 5. Thereafter, on 1 July 2025, the applicant received a notice from the inquiry officer of the case under section such and such, and in due compliance, the applicant appeared before inquiry officer on 2nd July and fully cooperated with the investigation by furnishing all information within his knowledge.
Yes, Mr. Ate, he has already appeared and he has already given his statements and he is cooperating with the investigation. What is the need of and keeping him inside the jail? Let him go. Because the allegation is only thing is that like he is in possession and he works for some.
It's a matter
certain
call for the
company.
case diary, matter in
I mean, whether- I
whether
mean-
he has a nexus with the other robbery and all, whether he was involved or not, that will ascertain from the case diary, matter.
No, that is true, but like at this stage, I mean,
Yes.
let him go in interim bail.
Yes, madam.
Let him go in interim bail. Heard, Mr.
K. Saxena.
A. Saxena, the learned counsel appearing for the accused applicant. Also heard Mr. T. Ate, the learned APP for the state. This is an application under section 482 of BNSS 2023 for praying for pre-arrest bail to the accused applicant in connection with Itanagar PS case number 102. So and so, you just write down all these things from here. So and so. The gist of the allegation as alleged in the FIR dated 172025 is that an organized interstate criminal racket is involved in buying, selling, transporting, and trafficking of various vehicles operating in Delhi as well as in this region. Full stop. The allegation it was also alleged that several vehicles from the other regions have been found and recovered by police in involvement in the instant case. Full stop. It was alleged that the accused it was alleged that from the position of the accused applicant, one Toyota Fortuner vehicle was recovered, which in fact on investigation it shows that the vehicle is in fact involved in a police case pending in
South Delhi.
pending in Delhi. Full stop. Pending in Delhi. On receipt of the FIR, the Itanagar Police Station case number 102/2025 was registered under the aforementioned sections. Next para you write, the learned counsel appearing for the accused applicant submits that that the accused applicant is in fact an employee of a company named, what is the name of your company?
Kengi Construction Company.
So and so, which is a sister concern of one other company, namely Messrs. Ocho Construction. Full stop. He submits that the Ocho Construction has in fact bought this vehicle by way of a sale deed from one Anita Lego of Itanagar. Itanagar on 22nd August on 22nd August 2022. He further submits that on receipt of a notice from the police investigating authority. Where is the notice?
Page number 20.
Under section 94, my lord. That is for production of document, my lord, or other thing. Not as an accused.
No. A notice under section 94, section 94 BNSS for production of documents relating to the seized vehicle, that is Toyota Fortuner White, bearing registration number AR/06A/0629. He submits that on receipt of the aforesaid notice, the accused applicant has already appeared before the investigating authority and submitted the required documents. He submits that since he is fully cooperating with the investigation and in the future also he is going to cooperate with the investigation, at this stage his custodial detention may not be required, and therefore he prays that the accused applicant should be at least given the interim pre-arrest bail at this stage. Learned APP, Mr. Iki, learned APP, on the other hand, submits that without perusing the case diary at this stage, this court should not allow the accused applicant to have the privilege of interim pre-arrest bail. Correct?
Yes.
Pre-arrest bail. This court has considered the submissions made by the counsel appearing for the respective parties, as well as gone through the materials brought on record. Full stop. In consideration of the entire things in entirety, and in considering the fact that the accused applicant has already appeared before the investigating authority and submitted the required documents, and his statements also been recorded, the accused applicant should be allowed to go on interim pre-arrest bail at this stage. Accordingly, it is directed that in the event of the arrest of the accused applicant in connection with the Itanagar PS case number 102/225, the accused applicant shall be released on interim pre-arrest bail on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the investigating or authority in connection with the Itanagar PS case number 102/25, subject to the following conditions: that the accused applicant shall cooperate with the investigation and he shall make himself available before the investigating officer as and when called for. That accused applicant shall not try to temper or hamper with the investigation in any manner whatsoever. That's all that will do.
My lord, let him appear within a week, my lord.
The accused applicant shall appear before the investigating authority within 10 days of passing of this order. Make it number one, number one. Then 2, 1, 2, 3. Then list the matter. On call for the case diary and list the matter on
22nd, my lord.
22nd.
Yes.
List the matter on 22nd. 22nd for further consideration.
Yeah.
Deeply obliged. Highly obliged.
Item number 3.
Yes, Mr. Bora is appearing on.
Yes, my lord.
Yes.
My lord,
Yes, Mr. Bora.
am I audible, my lord?
Yes,
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 my lord.
audible.
Lordship, my lord, yes. My lord, this is a quashing application, my lord. What happened in this case, my lord, the petitioner, he was a BDO, my lord, and allegation against him that he has deposited 5 lakhs of rupees in his personal account from the NREGA scheme, my lord,
Hmm.
and subsequent disbursed, my lord. That is the basic allegation. I am not on the factual metrics of this case, my lord. I am on the procedural aspect of this case, my lord. Lordship, first kindly turn to page 65. Page
Yes.
65, my lord. This is the
Yes.
initially, my lord, a complaint petition has been moved, my lord, in CGM SEPA against me, my lord, by 2 of the person, my lord.
Hmm.
The CR case number 08/2015. That
Correct.
the learned CGM, my lord, lordship, from page 53 to 63,
53.
on the basis of the complaint,
Yes.
53 to 63, my lord, recorded the deposition of all the witnesses, my lord. 4 witnesses.
Okay.
Complainant and his 4 other witnesses, my lord.
Hmm.
Deposition has been recorded. Thereafter,
Correct.
my lord, what he did, my lord, after recording the deposition, my lord, on the complaint petition number 200 and 202,
Hmm.
instead of proceeding further,
Hmm.
he has forwarded this case, complaint case, to the SEPA police station, my lord, for registration of an FIR.
Okay.
That lordship, page, my lord, page 51, my lord.
Page 51.
Page 51.
Hmm. Yes.
This is the order, my lord. Complainant are present along with the counsel. So they have submitted their statement and deposition on affidavit from such examination, and the complainant and his witnesses in person under section 200 CRPC is not necessary. Examination of the complainant number 2 has not submitted the statement in affidavit. Our learned counsel and also the complainant person seen the petition and perused the records annexed with the petition, which the complainant alleged to have obtained through RTI. After careful gone through the records, I find a prima facie case under section against Kipataro. Therefore, the OC SEPA is ordered and direct to register a case under section the provisions of law and to be investigation into the case and also to be submitted the report as per the provisions of section 173 CRPC. The complaint number 2 be examined by the police. It is shown unto me that though the Annex E series so-and-so petition, that the amount of rupees 5 lakhs has been directly transferred from the master account of the video Pake so-and-so personal accounts to the alleged accused Kipataro. Thereafter, there's directly the personal account of the accused Kipataro Biyojnava so-and-so maintained in SBS SEPA and other account, if any, is hereby freeze and smooth investigation and recover thereof. The complaint petition in original along with the annex deposition to be forwarded to the OC PS SEPA. They need not be examined as IO unless warranted after the further investigation in this case. The IO is to be proceed further to seizure of the material evidences of the case and arrest the accused person for interrogation. Copy of the order to SP SEPA, information of OC SEPA, for compliances. So, my lord, in this case, where he has already proceeded for 200 and 202. He cannot go back again for a direction for registration of a case under 156(3) CRPC. So that
Yes.
is we have challenged that part of we have challenged, this is the one of the impugn order, because he cannot go back because he has already applied his mind, taken cognizance of the material, applied his mind, proceeded for 200 and 202. Thereafter, he cannot go back under 156(3) for a direction to register a case. But instant case, he has gone back to the 156(3) and directed for registration of a case. And thereafter, what happened again, my lord? The said complaint, accordingly on the basis of this order, my lord, impugn order, same has been registered under SEPA PS case number 113/2015, my lord.
Where is that page?
113, the page 63, my lord. Same
Okay.
complaint, my lord. Page 63 is the
Hmm.
so
SEPA
SEPA. It was
PS case number
113/15.
Hmm.
So
Correct.
thereafter, my lord, investigation was carried on. Thereafter, they have filed the charge sheet, my lord. That is page 74, my lord. 74, lordship kindly look into. The page 74 is the first charge sheet they have laid before the magistrate court. Yes. So thereafter, my lord, what happened? During this case, the proceeding of this case, my lord, during the charge hearing, if in a petition, you can see the page 85. A petition was filed by
Yes.
SP, my lord, Vigilance, SP Vigilance,
Page 50.
page 85.
Page 85. Yes.
Yes. Now, what is their prayer was, my lord, that they are also getting the name vigilance because
Yeah, but voice is breaking. Yes, tell me.
yes,
Yeah, voice is breaking. Yes, yes. Got disconnected. You got disconnected.
they have
You got disconnected for some time. I could not hear you.
yes, now am I audible now?
I mean, slightly, not very. Anyways, carry on.
Am I audible now, my lord? My lord.
Now it's fine. Yes.
Yes. So, my lord, they have filed a petition that as the accused is a public servant, my lord, and they want to investigate case under the Prevention of Corruption Act. They made a
Okay.
prayer application
Prayer
before the
for the
CCM.
CGM.
Yes. That the case be entrusted to them for further investigation. So,
Page 88.
So, on the petition, my lord, the learned CGM, what he did, my lord, he has transferred the entire case, my lord, directly to the vigilance, my lord, with the case which is pending before him. He cannot transfer the entire case, my lord. What he did, my lord, he could have waited for the further investigation report under the PC Act. There is no bar as such for the further investigation. In this case, what he did, He has transferred the entire case record to the vigilance for the further investigation. That Lordship will find in page number
88.
88, my lord.
Yes.
Yes. This is the second impugn order, my lord. The heard both the learned to be on the point of the consideration of charge. That too in the point of charge, my lord. The learned as so submits as per the merit of this case, prima facie cases.
Got disconnected again.
Okay. My friend, can you try quickly? After some time, the last time.
You have disappeared, Mr. Bora.
My lord,
You have disappeared from the court.
I can see you, my lord.
But you can see me, but I can't see you.
That's a game of my lord.
I can't see you. I mean,
It's a game of Mr. India.
I think there is some problem going on today, right?
Am I not?
Internet connections. Internet connections. There was some problem, some network problem today.
I see in here.
Can you try as last item, Lordship? As a last item, can we try it again?
Yeah, we can. I mean, we can take it up after some time. If
Yes. After some time.
after some time means when?
Yes, my lord.
Again, you are appearing. Yes, yes, yes.
Just my few points on. Now, this is the impugn order page
No.
88.
Yes, page 88. I have seen. Yes.
Of the order.
You are not audible now.
Page 18.
You are not. You are not audible, Mr. Bora now. Not audible at all. Not audible, Mr. Bora. I can see your face, but no voice is coming. No voice is coming from your side. No audio is coming. Though video is there, video is still video. No movement of your face or lips. I can make out from your lips also. Not audible. What is to be done?
Am I?
Can we try after some time, Lordship?
Mr. Bora, can we try after some time? There is some network problem, it seems.
My lord, my lord, my lord.
After some time, we'll take your local council is there. So we'll take it up after some time when the network improves.
My lord, hopefully, my
Okay.
lord. My lord.
Okay. We'll take it up after some time.
Item number 4.
My lordship, this is criminal petition.
Hmm?
This is criminal petition by
Yes.
under section 528 of BNSS. Here, lordship, I have to challenge the impugn order that 15/5/2024 passed by the learned Chief Judicial Magistrate West Siang District, Alo, Arunachal Pradesh, on 3 aspects, Your Honor.
Hmm.
First is that, Your Honor, petitioner, the accused petitioner has been issued summon in violation of section 204 clause 2 of CRPC.
What is the violation?
That
20?
204 clause 2 of CRPC.
What is that?
No summons or warrant shall be issued against the accused under subsection 1 until a list of the prosecution witness has been filed. Now, more than 10 hearings have been permitted, and I have been appearing here for more than 1 year. After that, this list of this prosecution witness is filed by the complainant only. And this is their first. And second is that at the time of pre-cognizance stage, whether that the complainant, that the learned magistrate has record the statement of the complainant under oath or not, that is also not sure, Your Honor. Here, Your Honor, this case has been reached at the stage of examination of the witness. When the case has been already reached at the stage of the examination of the witness, then I have filed one CTC just to know what statement have been made before pre-cognizant stage, before the magistrate. Then I have not furnished that what statement has been made by the complainant before the magistrate. There are two procedural lapse aspects there. And third is that this is case that is the case of the defamation. An entire statement made by the petitioner, there the name, place of posting has not been mentioned by the petitioner against the complainant. These are the three aspects, Your Honor, that I have approached before this honorable court to quash and set aside the cognizance order, impugned cognizance order made by the Chief Judicial Magistrate Alo, Your Honor. It's there.
So one is that, I mean, you are saying the first ground is that
Without filing that the prosecution witness, the summon has been issued to the petitioner
without filing prosecution witness,
under section 204 clause 2 of the CRPC.
okay, let's see about 2042.
Another is that whether the statement of the complainant before the cognizance has been recorded or not under oath. That is also not sure, Your Honor. And third aspect is that in entire is the speech made by the petitioner, that the name and place of the posting of that complainant has not been made.
No, I didn't get it. What the statement? The entire,
Defamation.
I mean, basically defamation was filed for what? For giving a speech,
Yes,
giving a public speech.
yes, Your Honor.
And public speech, what was not mentioned?
The name of the complainant
Name of the complainant was not
and
there.
place of the complainant was also not mentioned. Name of the, here the complainant is the DIG, and who was posted as jail in charge of the Jolly jail. And in my entire speech, I have not mentioned the name of this complainant. And even I have not mentioned the place of the posting of this complainant.
But that is on merit. But I
Yes,
mean,
sir.
you are discussing. I mean, you are challenging this on procedural aspects or what?
Yes,
Hmm?
on these three aspects.
Yes. Let us see 202. 202.
204.
Sorry,
clause 2.
2042. CRPC. It is under BNS or
CRPC.
CRPC?
Section 204, clause 2.
So this is a summons case,
Yes,
or it's a summons case, right? We can-
yes.
And your allegation is the statement of the complainant was not recorded.
Yes, Your
Under which section statement has to be recorded?
200.
The respondent number one is who? He's the DIG.
Complaining.
He's the DIG. And from where you are saying that list of witnesses were not filed?
Your Honor, kindly, Your Lordship may find this page number 84 of my petition.
Page number
84.
84.
Yes. This is the one of the order where that the complainant
number-
has read that he may be allowed to file the revision list of complainant witness, list of witness. Now list of witness has been
No,
filed.
84 you see, what is there? What is there in 84?
Page number 84. This is the order copy.
Yes, what is there?
There that the complainant has made a prayer before the court that he may be allowed to file the list of witness. And this application they have filed after the 1 year. And
1 year of issuance of summons.
yes,
Hmm?
yes. And even 10 trial was already conducted. And the case is at the stage of examination of witness.
No, he's saying about the revised list of CWs. He's not
Uh,
saying about, I mean, it's not that he has not filed the,
Here he has said that revised list, but he
no,
has
wait,
not
I mean,
filed-
see, I mean, if you read this bottom paragraph,
Yes, Your Honor.
the learned counsel for the complainant has prayed for some more time to file appropriate petition for allowing him to adduce additional documents and to file a revised list of CWs. The prayer is considered and allowed. So that means that it was filed, but he's just praying for a revised list.
He prayed for the revised list, but no list was filed, Your Honor.
Now, how do you know? How this court will
Uh,
know about this?
Kindly see the page number 86.
Sheet number
86.
86.
Yes. Annexure 4. These are the list of witnesses submitted by the complainant on 10/8/2025 after 1 year.
The list
And
of
he-
witness submitted on behalf of complainant.
Here that the first witness is
Yes,
Let me-
Mr. Genie, what is that?
Your Lordship, first of all, this order dated 2/6/2025 is not under challenge, Your Lordship.
No, this is not, I mean, 262025.
Yes, where,
No, 202625, I mean, it's not challenged because it's, he's challenging on the basis of the legal point, I mean, procedural lapses.
yes, Your Lordship.
So he doesn't have any, I mean, he may not be having any grievances against this.
No.
But what he's saying that he's basically challenging the issuance of notice,
Yes,
not this,
yes,
not this one. There is nothing to be challenged in this order.
yes, Your Lordship.
See, he is challenging that like notice, summons were issued to him, right?
Yes,
And summons were issued to him without having the list of witnesses. So this order, I mean, reveals that list of witnesses were not submitted. That is his, I mean, submission.
Submission.
Correct. So this order, you need not be challenged.
Absolutely, Your Lordship. Only to point out that revised, there was an early, if we read this order, Your Lordship.
So we'll have to look
Revised-
into, we'll have to look
Into
into.
the
we'll have to-
record, Your Lordship.
we'll
Even
have to look
otherwise
into the
also,
record.
Lordship will see other orders. If I may take Your Lordship to page number 82.
Page number 82, yes.
Lordship will see the last paragraph, complainant and complainant witnesses shall be examined on the next day. So if there was no witnesses as such, list of witnesses submitted, Your Lordship, this order.
Yeah, that
is
is, yes, that is what I was asking, because
Yes.
this is of 18/7
2024,
and the other order was of 26/2025.
25, yes.
So it was earlier.
It was earlier, Your
Hmm.
Lordship. Now, again, at page number 83, Your Lordship will see on the next date, presiding officer is on leave, hence the case is refixed on so-and-so date for CWS as per order, complainant witness shall be examined on the next date. Your Lordship will see that this is an order of 2024, Your Lordship.
Till that, I was not furnished the list of witnesses.
Now, in terms of, Your Lordship will see that with regard to provision of 2042, as per the orders, Your Lordship, it seems that there was a list of witnesses which can be ascertained once the TCR is being called for, Your Lordship, otherwise.
So, I mean, till that time we'll stay,
Why don't
we'll stay. Heard, Mr. So and so the learned counsel appearing for the petitioner. Also heard Mr. M.S. T. Gini, the learned APP for the state. This is an application under section 528 of BNSS, 2023 for quashing and setting aside of the order dated 15/5/2024 in connection with complaint case number 12/2024. Pending before the Chief Judicial Magistrate, Civil Judge, West Young District, Alo, Arunachal Pradesh, full stop. The learned counsel appearing for the petitioner submits that there is a procedural lapse in passing the order dated. Where is the order? Which page?
Page number 21.
Page number
21.
21. Passing the order dated 15/5/2024, whereby the learned CJM has issued summons on whom?
He is non-accused, Your Lordship.
Sole dudum is whom?
Accused.
Present applicant.
Applicant. Summons to the petitioner, that is accused in the case pending before the learned CJM. Full stop. The learned counsel submits that while issuing the summons by order dated 15/5/2024, the accused person was not served with the list of witnesses, which is mandatory as per section 204 in bracket 2 of CRPC. Full stop. He further submits that he further submits that the statement of the complainant was also not recorded before taking cognizance in the instant case by the learned CJM. Correct? In view of the aforesaid procedural lapses, he submits that the order dated 15/5/2024 is an illegal order, and therefore the same should be set aside and quashed. Correct? The learned APP, T. Gini, the learned APP, on the other hand, submits that there is no procedural lapse in the instant case, as could be seen from the order dated 262025, correct?
Yes, sir.
2620262025
Uh,
2025 wherein whereby it reveals that a list of witnesses is already available before the learned court, before the learned trial court. Full stop. This court has gone through the materials available on record as well as heard the submissions made by the respective counsel appearing for the parties. After considering the aspect that the statement has already been recorded.
Statement, Your Honor, that I have filed that the CTC for the purpose.
No,
of
but
the
your submission is not
examination.
correct. It has been stated the submission has been recorded, statement has been recorded.
That statement has to be recorded under oath. And that statement I have filed CTC. for
No,
the
no,
purpose
whether
of
it has
the
been taken on oath or not, I mean, you are not sure, you have not submitted any document in that respect.
In order copy, it is recorded that the statement has been recorded under oath. But I have that the filed CTC to obtain that document from the court, and I have not been furnished, Your Honor.
Right, from the materials bottom, on perusal of the materials before this court is unable to ascertain whether the list of witnesses is available before the trial court or not, and to whether the list of witnesses has already been handed over to the accused person. Correct or not?
List of witness has been first list of witness I have not been handed, but on 10/8/2025, after 1 year, I have been handed over one IA where the list of witness has been there only after 1 year.
But anyways, you have been given, but someone so issued when? Only on 5/15/5.
Yes.
But list of witnesses have been given to you when?
10/8/2025, after 1 year.
10/8/2025.
Yes, Your Honor.
But you have been given, na?
That should be filed before the taking cognizance and before issuing of the summon to the accused.
What is written last time? Could not be ascertained whether list of the witnesses were given. List of the witnesses was given to the accused person prior to issuance of the summons. Though it could be seen from the record that a list of witnesses has been handed over to the accused person
On 10
on 10
2025.
huh?
On 10/8/2025.
From where do I get it? This is a type copy. This page 86.
86. This is not type copy. This is the IA file by the complainant.
IA file, okay.
And this IA is still pending.
Already handed over to the accused person, which could be seen from the IA. which could be seen from the IA number 12/2025 filed in the criminal complaint case number 12/2024 by the complainant. Full stop. Looking into the entire facts involved in the case, this court is of the considered opinion that notice should be issued in the instant matter to the respondent number 1, and in the meantime, the proceeding before. In the meantime, the proceeding before the learned CJM Alo of West Siang District, Arunachal Pradesh, in connection to criminal complaint case number 12/2024 is stayed until further orders. A registry to call for the TCR in connection with complaint case number 12/2024 pending before the Chief Judicial Magistrate, Alo, West Siang District, Arunachal. Steps to be taken for issuance of notice on respondent number 1 by speed post within a period of 3 days from today. Notice to respondent number 2 is dispensed with as learned APPA entered appearance in a matter. Full stop. Release the matter after 4 weeks.
Yeah.
Item number 3, it's a passport for the timely matter.
My lord,
Yes, page 88, Mr. Bora.
yes, 88 and Lordship kindly 89, my lord.
Ah.
9, the middle paragraph, my lord. Pending trial of this case, the SIC has filed an application with a prayer to allow them to investigate the case as alleged offense of the accused Kripa Taro was committed while discharging public duty, and the thereby offense is to attract the punishable under Prevention of Corruption Act 1988 in addition to the 409 IPC. The relevant copies of the petition SIC were made available to both the parties. I have carefully gone through the facts of this case and prayer of this so-and-so vigilance, Itanagar. According to him, the matter was inquired by Pooja Jain, IS, ADC SEPA on being directed by the vigilance officer cum Chief Executive Officer East Coming SEPA, Sri Sandeep Kumar Singh. The report was submitted on 1/1/15 by the District Vigilance Officer, Chief Executive Officer, District Rural Development Agency, East Coming SEPA to the Principal Secretary Vigilance Government of Arunachal Pradesh, Itanagar, which is recommendation to initiate appropriate action against the accused Kripa Taro for misappropriation of the MNREGA fund. During the correspondence with the OCPS SEPA, I had come to their knowledge. It had come to their knowledge that a case was already registered against the accused Kripa Taro at PS SEPA under section 409, 420, 471, 468, 34 IPC. Considering the above facts and circumstances, I am of the view that the SIC Vigilant Government of Arunachal Pradesh, Itanagar, was unaware of the dark position and thereby they were not able to take cognizance of the offence under the relevant provisions of the Prevention of Corruption Act. Therefore, I am of the view that since the trial of the case has not been begun, an opportunity to investigate the case by the SIC Vigilance will not prejudice the accused. In view of the above, I hold the opinion that an opportunity to be investigating the case SIC Vigilance Government of Arunachal Pradesh has not been in the eyes of law. Therefore, the case returned for case vigilance for further investigation and file a such this is also important to file a such special court on finding privacy case against the accused if accordingly this case is disposed of with an evaluation case accordingly. But that is we have challenged because once he filed before a competent court, he has to, if there's an application, there is a provision for the further investigation. The decision can do further investigation. The court could have waited for the further investigation. Instead of that, he has transmitted the entire.
Again gone, Mr. Bora.
Case was, my lord.
Yes, again you are coming back. Yes. I could not hear in
Yes.
between. You disappeared.
Yes, my lord. Sorry, my lord. Probably because there
No,
is
no, I
some.
mean, there is some network problem. I mean,
Yes, yes, because we are on the Zoom meeting, my lord. That's the problem, my lord. So, my lord, my contention is that first of all, the magistrate, without, my lord, when he has already applied his mind, my lord, first of all, and once he has proceeded for 200 and 202, he cannot go to the 156.3, go back to 156.3 and direct for the registration of the case. That is the first contention. Second
the
contention is
registration of the case before the SEPA police station.
yes.
Hmm.
And
And
secondly,
after the,
after that, yes, my lord, when the trial is about to begin, my lord, it is on the point of charge. At that stage, the court cannot return the entire case to the investigating officer. He could have waited for the further investigation to material to come. If there is a material under Section, my lord, Prevention of Corruption Act in the further investigation, then he has to transmit the record not to the police but to the special court, which has the only jurisdiction to try the offence under Section Prevention of Corruption Act, designated court under the PC Act. But here, and furthermore, he has exceeded his jurisdiction by ordering that case has to be registered under the Prevention of Corruption Act. That is the prerogative of the investigating officer. Or he is neither in special court, my lord. Only the special court has the jurisdiction to add the Prevention of Corruption Act, their judgment to that effect, not the other courts. He being the CM, my lord, he doesn't the section of most important cases. How he can transfer the whole record,
the voice has gone
which
again.
he is holding, my lord.
Your voice has gone again.
Yes, my lord, am I audible now?
Breaking. Yes, yes, carry on.
So, my lord, this is the 2 point, my lord, we are harping on at this
So
petition, my lord.
one
this
point is
the
that like,
beyond jurisdiction.
no, correct. One point is that like, I mean, that illegal order of, I mean, asking the SEPA police station to investigate and register a case, the first one.
My lord.
And the
My lord.
second one is that once SEPA police has done the investigation and submitted something, submitted a report, and it was at the time of the charge, an application was filed by the vigilance for transferring the case to the vigilance department, because they wanted to investigate. That magistrate doesn't have the power to do so, because if there is some element of PC Act, then the special court, special court should have special court ought to have the jurisdiction, not by the chief judicial magistrate. So he went beyond the jurisdiction. Is that so?
Yes. And yes, Lordship is absolutely correct. And the third one is he doesn't have jurisdiction to return the entire file. He could have waited for the further investigation by the vigilance.
Then he could have correct, after considering the materials by the vigilance department report, then he could have sent it back to special court for further consideration.
Yes, Lordship. Lordship is absolutely correct. Yes. That is the contention. Yes, that is our contention. Well, on the basis of this, my lord, they have filed the second charge sheet, my lord. We have challenged that also. Now, Lordship can kindly take up these. There are few judgments we are relying on.
Correct. Please.
Submitted. So, Lordship, can we see the first judgment? That is, my lord, 1991, my lord. No, sorry. 1976, my lord. 76.
1976. Yes. Para 13, 14, 16.
Yes. 14 is only important, man. Only 14, man. 14 will
14.
do. Yes.
Yes.
This raises the incidental question that is meant to by taking cognizance of offence by a magistrate within the completion of section 190. The expression has not been defined in the code, but from the scheme of the code, the content of marginal heading of section 190 and the caption of chapter so under the section so occurs, it is clear that the case can be said to be instituted in a court only when the court takes cognizance of the offence alleged therein. The way in which such cognizance can be taken are set out in classes A, B, C, and section 191. Whether the magistrate has or has not taken cognizance of the offence will depend on the circumstances of the particular case, including the mode in which the case is sought to be instituted and the nature of the preliminary action, if any, taken by the magistrate. Broadly speaking, when receiving a complaint, the magistrate applied his mind for the purpose of proceeding under section 200 and the succeeding section of chapter so and so, he is said to have taken the cognizance of the offence within the meaning of section 191A. If instead of proceeding under section 15, he has, in the judicial exercise of his discretion, taken the action for some other kind, such as issuing the search warrant for the purpose of investigation or ordering to investigation by the police under section 156(3), he cannot be said to have taken cognizance of the offence. So, my lord, from here, it appears, my lord, he has already recorded, CCM already recorded the statement of the all the witnesses in the first complaint itself. So, he has taken the cognizance. So, once he has taken the cognizance, he cannot go back to 156(3) for direction of the, that lordship will find that our High Court, my lord, 2011, 2 GLT 610, my lord. Paragraph 76. 2011 GLT, my lord.
2011
Volume 2,
GLT
610, lordship.
20610. Yes. Paragraph
It's a division bench judgment 76.
paragraph 76.
Yes, Lord.
Yes.
Yes. Yes, Mr. Boy.
Broadly speaking, when on receiving a complaint, the magistrate applies his mind for the purpose of proceeding under section 200 and succeeding section of chapters 15 of the code, he is said to have taken cognizance of the offence within the meaning of section 190A. If instead of proceeding under section 15, he has, in the judicial exercise of discretion, has taken some other kind, such as he issued search warrant for the purpose of investigation or order investigation by the police under section 156(3), he cannot said to have taken cognizance of the offence.
So in your case,
Now-
what you are submitting is that since the examination of witnesses have already been completed, so that shows the cognizance is already taken, so he cannot return to 156(3). That is
Yes.
what you are saying?
My lord, 84. Yes, my lord, 84, lordship, next paragraph.
84.
Yes.
Yes.
The imperative, it is to the point out that the power conferred on a magistrate to direct investigation under 156(3) is quite different from the power given to him to direct investigation under section 2021. The power so conferred is resorted to two distinct and different sphere and two different stages of emphasis by the court. The court is to the pertinent to the reiterated has made the distinction between the precognizance and post-cognizance stage. While 156(3) deals with the magistrate, the powers to direct investigation at the precognizance stage, section 202 empowers the magistrate to direct investigation by the police at the post-cognizance stage only for the purpose of limited investigation under section 202 in a complaint case. In a complaint case also in 202, lordship knows that the investigation can be directed for limited purposes, not the investigation by the police. It's a different investigation. So here already, my lord, the magistrate has taken cognizance and he has proceeded for 202. So he cannot go back to 156(3) to direct the investigation by the police for the entire case. So that is the case, first one. The second one, my lord, now once the trial, the charge sheet has been laid down before the court, and he cannot direct the investigating officer to register a PC Act, my lord, because he is not a special court. That lordship will find in, my lord, 1991 2 GLR 445.
Yes.
Sampat Mal changes.
That paragraph 22, my lord.
Yes.
As a corollary to the above proposition of this paragraph, the question may arise, as in fact has arisen in a case in hand, whether subsequently provisions of the Act can be allowed to be added during the investigation, if so, by which court? Admittedly, when a normal investigation police is proceeding in a competent court is to keep informed, and subsequent addition of any section of the Act by the investigating authority cannot be allowed to be done by the ordinary criminal court, as the power of such court under the Act is confined only to the remand of an accused person. Such an order of allowing investigation agency can be passed only by the designated court and not by any other criminal court. In allowing the investigation agency to add any provisions of the Act, it is duty of the designated court to examine very carefully all the materials produced before the court, and speaking order has to be passed keeping in view and ratio of the apex court as stated above regarding the application of the provisions of Act. Such order shall not be passed, and it shall be speaking order which reasons the cases in hand, along with the prayer for aiding the provisions of the Act. No materials should be disclosed, and that part the order were passed by the magistrate in the most mechanical way without any reason. Not only these orders are without the jurisdiction. So in this case also, my lord, a magistrate has allowed to add a special provision, the PC Act, my lord, to the investigating authority after the, my lord, first remand. Then the court says only the special designated court can add the special act, not by the normal criminal court, my lord. That is the law, my lord. So here the CGM has directed the investigating authority while returning the case record to register the case under the Prevention of Corruption Act directly. He doesn't have that jurisdiction. And secondly, he cannot return back the case record. Well, that is atrocious, my lord. He is holding the case, he is going to proceeding, my lord, and he is returning the entire case record. Only you could have waited for the further investigation. And if there is any material on further investigation under the Prevention of Corruption Act, only then he has to transmit the record to the special court, designated court, which has the power to try the PC Act. So that is the provision, my lord. Here, my lord, it is all has been flouted, my lord. That is why we have challenged these orders, my lord. That's all, my
lord. I am appealing for the state, my lord. My lord, I would differ with the senior, my lord, as regard to the power of further investigation by the magistrate. Here under 156(3), my lord, the magistrate has every power, my lord, to direct for further investigation, my lord. But subject to the fact that once the special court take cognizance of the matter, he doesn't have that power, my lord. But before taking cognizance by the special court, my lord, he has the power, my lord, under 156(3).
No, you have this court has already taken the cognizance, right?
No, no, my lord, we have not taken the cognizance.
Why? The statements have been recorded. I mean,
that was in the CR case, my lord. That was in the CR case, my lord.
Correct.
In the CR case, my lord, and he has given a direction to file an FIR, my lord. Now that FIR was registered, my lord, and thereafter, my lord,
No, you have taken the cognizance after that. What I mean, what is the I mean, why this SEPA case was again to be raised?
because, my lord, it was a direction from the CJ, my lord, of taking cognizance. It is a CR case, my lord, and prima facie there was a case of corruption, my lord. But what they did, they have given it to the regular court, my lord. Regular police station, my lord. What ought to have happened was that the regular police station would have transferred those cases to the SIC, my lord.
No, rather than doing that, I mean, an investigation could have been done by the police. That is there.
No, that could not have been done, my lord. Why? Because they don't have the power to investigate, my lord. When there is a PCS,
PC has come later on, and PC was when a PC was tried to be invoked on an application filed by the vigilance.
Yes, my lord.
Later on.
Yes, there is an
But before that, there was some procedural lapse as been contended by the Learned Senior Counsel.
No, my lord. I would differ with that, my
No,
lord.
differ with what? He has shown a case also.
Yes, my lord.
He has shown a case also, right? He has referred to this case. What is your answer to that?
Okay, my lord. Two 17 SSC, my lord.
On what point?
The powers under 156, my lord.
Hmm?
The powers under 156, my lord.
At what stage?
It can be even after taking.
Para.
Para, my lord. It starts from para 15, my lord. 15.
1-5.
Yes, my lord.
Yes. What does it say?
It's
Para 15 and?
It's a very lengthy judgment, my lord.
No, you tell me what I mean. Lengthy does we have the whole day. You tell me.
My lord. Then may I read it, my lord?
Para 15 and which paragraphs?
Para 15, 20,
Huh?
23.
Wait a second. Wait, slow. Para 15.
Yes, my lord.
Then
20.
20.
20.
Huh? Para 15, 20 and
21.
21.
21 to 25.
21, 25.
Till 30, my lord.
21 to 30.
30.
Yeah, what is the gist?
Now, my lord, the powers of the magistrate under 156(3).
Yes. Let's see 15.
Yes, ma'am. May I read it, ma'am? The Israel Code of Criminal Procedure so did not contain the provisions by which the police was empowered to conduct the further investigation.
No, where are you reading?
15.
The Astral code, no?
Yes, ma'am.
Astral code, so and so did not connect. Correct.
Yes.
Go on.
Provisions by which the police was empowered to conduct a further investigation in respect of an offense after the police report was under section 173 has been forwarded to the magistrate. The 41st Law Commission report has been so and so forwarded to the Ministry of Law and so and so. Now, down below, my lord, I'll just come to the point, my lord. Reopening of investigation. The report under 173 is normally the end of investigation. Sometimes, however, the police officer, after submitting the report under section 173, comes upon evidence bearing on the guilt or innocence of the accused. We should have thought that the police officer can collect that evidence and send it to the magistrate concerned. It appears, however, that the courts have sometimes taken the narrow view that once a final report under section 173 has been sent, the police cannot touch the case again and cannot reopen the investigation. This view places a hindrance in the way of investigation agency, which can be very unfair to the prosecution and, for that matter, even to the accused. It should be made clear in section 170 that the competent police officer can examine such evidence and send a report to the magistrate. Copies concerning the fresh material must be furnished to the accused.
Then there are 20.
Yes, madam. With the induction of section 173(8) in the CRPC, the police department has been armed with the power to further investigate an offense even after a police report has been forwarded to the magistrate. Quite obviously, this power continues till the trial can be set to commence in a criminal case. The next question before us is as to whether the magistrate can order further investigation after a police report has been forwarded to him under section 173.
Yes.
No, 21, my lord. And that's- Next para, my lord.
Mhm.
21, the relevant would be in the next page, my lord. Page
Yes.
17, page 17, my lord.
Yes.
1, my lord.
Hmm.
Subclause 1. Agree with the report of the, if after the filing of the report, my lord, he agree with the report of police and file the proceedings or not agree with the report of the police. Order further investigation or hold the evidence is sufficient to justify the forwarding of accused to the magistrate and take cognizance of offense complained of. The appropriate course has to be decided upon after a consideration of the report and the application of mind of the magistrate to the content thereof. But then the problem to be solved is whether the order passed by the magistrate pertains to his executive or judicial capacity. In my opinion, the only order which can be regarded.
So we'll continue. Mr. Bora will continue at 2.
My lord.
We'll continue at 2.
Your Lordship, I beg to mention item number 8. The matter has been adjourned for today, Your Lordship. There is a interim. It may be continue.
Okay, that item number 8 is this,
Okay.
interim order so pass.
I beg to mention, my lord, with regard to item number 7, my lord. What happened this morning, my lord? It is a misunderstanding, my lord. That date has been fixed on 2nd February, my lord. And my lord, the engaged counsel is the senior counsel Satyan Sharma. So he telephonically called me and he sent me the message also. He had a discussion with the senior counsel Majumdar, opposite counsel, and both of them had agreed that the matter to be fixed on 22nd of December. So, but because of some misunderstanding only, my lord, that matter got postponed to February, my lord. There is urgency in the matter, my lord. Earlier also 3 attempts were made to get the matter disposed, my lord. So expressing urgency, senior counsel Satyan Sharma has requested me to mention again so that taken the consent from of the senior counsel Dilip Majumdar also, that this matter may kindly be fixed on, my lord.
No, it was specifically stated before this court.
Yes.
In the morning, by senior counsel, Mr. Majumdar, the 22nd, it will be difficult for him.
My lord, that's very unfortunate, my lord. But that's my lord. Message repeatedly, I will send message even, my lord, that the council has agreed for the matter to be fixed on 22nd.
The 22nd, I mean, Mrs. Majumdar has agreed for that.
Agreed, my lord. This message even, my lord, my lord.
No, I don't want that, but I mean, but in the morning it was specific. Who is the local counsel? Local counsel for Mr. Majumdar?
He is, he left, I think. My lord.
But
I
what
am
to be
for
done? I mean, we have already fixed on 2nd.
Yes, that is there. And even he was told that to one Mr. Deori, he would present at 2. This was informed to senior counsel Satyan Sharma also.
No, Mr. Who is appearing? Who is the local counsel for Mr. Sharma here?
Deori only.
Deori is no longer not there.
I am for respondent number 1.
And Deori is not there in the court now.
He is not there since. I have telephonically called him personally. Then he said that he has no objection. And he said that somebody he would depute, but it's not there. But I even personally call him to Deori. So.
Item number?
11, my lord.
Second will be the. Okay. 22nd, it will be a little bit difficult. Any other day?
My lord, then 23.
We can fix it on 23 till all the consent council.
23,
I don't know
my
when
lord, I'll be having difficulties.
Hmm?
23, I'll be having difficulties.
will be available.
No, I'll be not available.
Then what is
In
to be
that case,
done?
my lord, 22nd, if
The
both the
22nd
senior
may be
councils,
difficult because this court, this court, I personally like if, I may not be able to come, I'll be reaching here in the night. So taking up the matter of this polling may be difficult. 23rd, if it is
in that
possible.
case, as suggested by the senior council, maybe on first week of January, my lord.
No, we must
Seven
suggested on 22nd. Both of the senior council, of course, my lord's convenience, subject to the my lord.
Let us fix on 22nd.
22nd, 22nd, my
No,
lord. If they are,
22nd.
they both are ready, 22nd.
They are very, so let it be fixed on 22nd.
My lord.
22nd. Please intimate the council. Mr. Majumdar also please can intimate
lord.
that it isn't fixed on 22nd. Majumdar has given consent, right?
He said,
My lord,
Both the
that's,
seniors, they have-
even message even given to me, my lord.
That to be fixed on 22nd?
Yes, my lord. Deeply.
22nd, yes.
highly over.
Yes.
Item number 3.
Yes.
And this, one more para, my lord, regards to whether further investigation can be directed after taking cognizance or not.
Hmm.
This is the same judgment, my lord, in the same judgment,
Para?
my lord. There are 31,
There are 30.
31, 31. It is an important judgment which deals with the necessity for further investigation being balanced with the dealing of a criminal proceeding. If there is a necessity for further investigation, when fresh facts comes in light, then the interest of justice is paramount and trumps the need to avoid any delay being posed to the proceeding. The court hereafter held, coming to the question as to whether further investigation is warranted, the hands of the investigating agency or the court should not be tied down on the ground that further investigation may delay the trial. Thus, the ultimate object is to arrive at the truth. Subsection 8 of subsection 173 of the court permits further investigation and even deholds any direction from the court. As such, it is open to the police to conduct further investigation even after the court took cognizance of any offense on the strength of the police report earlier submitted. All the more, if, as in this case, the head of the police department also was not satisfied with the propriety or the manner and the nature of the investigation already conducted. It was observed by this court that further investigation is not altogether ruled out merely because cognizance has been taken by the court. When defective investigations come to light during the course of trial, it may be cured by further investigation if circumstances so permitted. It would be ordinarily be desirable and all the more so in this case that the police should inform the court and seek formal permission to make further investigation when fresh facts come to light instead of being silent over the matter, keeping in view only the need for an early trial since an effective trial for real or actual offense found during the course of proper investigation is as much relevant, desirable and necessary as an expeditious disposal of the matter by the court. In view of the aforesaid position of law, if there is necessity for further investigation, the same can certainly be done as prescribed by law. The mere fact that there may be further delay, this is not. Now here, what I am humbly submitting is that, my lord, even after taking cognizance also.
So let us see the consequence, okay? And let us see the, this thing. How it has come, it has come up.
My lord.
So
therefore, my lord, at this stage, it is in the motion stage, my lord. I'm not burdened, my lord, with other judgments, but then at this stage, may I humbly pray, my lord, the trial court request may be called for, my lord. It's the scan copy of the trial court request may be called for.
and we'll set up proceeding for a time being. And when the case record comes, then we'll consider it. Yes, Mr. Bora.
My lord, my lord.
So we'll consider it when the
Well,
when scan copy of the trial court comes, but till that time we'll do this.
yes, madam.
Take down. No? Heard Mr. A.M. Bora, the learned senior counsel, assisted by Mr. D.B. Bodya, D.K. Bodya, the counsel appearing, D.K. Bodya as well as Mr. Phil Lolan, the learned learned counsel for the petitioner. Also heard Mr.
Wopada Manot,
Wopada, the learned
Special PP,
Special?
ACB, man. ACB,
special
Public Prosecutor,
procedure for
Anti-Corruption Bureau.
so the instant petition has been filed under section 528, read with section 442 of BNSS 2023, praying for setting aside and quashing of the proceedings of special case number 01/2025 under section 409 of the IPC, read with section 13 in bracket 2 of the Prevention of Corruption Act 1988, pending before the Court of Learned Special Judge in bracket Prevention of Corruption Act, 1988, UP Papum Pare, Arunachal Pradesh. The case of a petitioner is that the petitioner is facing prosecution in special case number 01/2025 under section 409 of IPC, read with section 13(2) of PC Act 1988, pending before the learned special judge, special judge in bracket Prevention of Corruption Act 1988, UP Papum Pare, Arunachal Pradesh, wherein the case was originated from a complaint lodged by respondent numbers 2 and 3, being CR case number 8/2015 before the learned Chief Judicial Magistrate, East Covering District at SEPA. Full stop. Provide an impugn order dated 6/10/2025, passed in CR case number 8/2025 by the learned Chief Judicial Magistrate, SEPA, directed the registration of the FIR in SEPA PS case, SEPA FIR in SEPA PS case number 113/2015 under section 409/420/471/468/34 of Indian Penal Code 1860. Subsequently, the charge sheet wide
That's it by number 15 of 2016.
subsequently charge sheet number
15 of 16.
15 of
2016.
2016 was filed.
Yes.
Was filed before the Chief Judicial Magistrate. Chief Judicial Magistrate. Chief Judicial Magistrate is Covering District
Yes.
at SEPA. Subsequent to such filing of the charge sheet, wide an impugn order dated 11/11/2016 passed in GR case number 127/2015 corresponding to SEPA PS case number 113/2015 The learned Chief Judicial Magistrate transferred the investigation to Anti-Corruption Bureau in bracket ACB Itanagar and directed the investigating agency to file a charge sheet under the PC Act 1988. It is the case of the petitioner that the impugned FIR number 132016 registered by the ACB Itanagar, being a consequential action arising out of the impugned order dated 11/11/2016, on completion of the investigation, don't write, it is the case of the petitioner. You just simply write the impugned FIR, so and so, so and so, completion of the investigation. Subsequently, charge sheet number 01/2025 dated 28/1/2025 arising out of the ACB Itanagar FIR number 13/2016 registered under section 409 of IPC, read with section 32 of PC Act. PC Act, which is numbered as special case number 01/2025 under the aforementioned sections pending before the court of Lawrence Special Judge UPA, Papumpare. And the same is fixed on 9/3/2026 for consideration of charge. The contention of the petitioner, next contention of the petitioner is that the respondent number 2 and 3, white letter dated 25/3/2025, before the DC is coming SEPA, alleged that the petitioner, while functioning as block development officer stroke program officer of Pakke Kesang CD block, East Coming district, had willfully and deliberately misappropriated funds allocated under the Mahatma Gandhi National Rural Employment Guarantee Act in bracket MGNREGA bracket complete. It was also alleged in the FIR, in the aforesaid letter, in the aforesaid complaint, that the petitioner had violated the prescribed guidelines of fund disbursement, coerced panchayat leaders into signing blank checks, procured materials at inflated costs, issued checks without obtaining requisite joint signatures, and thereby diverted public funds for personal benefit and for benefit of his close relatives, and thereby committed offenses involving criminal breach of trust, cheating, and misappropriation of public funds. Next, pursuant to the complaint lodged by the respondent number 2 and 3, the DC, West Cumming, SEPA, by order dated 25th March 2025, endorsed the matter to the Additional Deputy Commissioner, SEPA, for conducting a preliminary inquiry into the allegations made against the petitioner. After completion of such preliminary inquiry, the additional DC submitted her inquiry report on 18 September 2015, wherein various allegations were made against the petitioner regarding mismanagement in disbursement of MG and REGA funds. The date has been given, 18th. After submission on receipt of the inquiry report from the ADC SEPA, the DC West Cumming, East Cumming District by letter dated 1st October 2015 forwarded the same to the Principal Secretary Vigilance, Vigilance, Government of Arunachal Pradesh, Itanagar, for necessary action. Necessary action by recommending the initiation of appropriate action against the accused petitioner, against the petitioner. In view of the submission of the report by the ADC before the DC, a criminal complaint before the learned Chief Judicial Magistrate SEPA was lodged on 1/10/2015, and the same was registered as CR case number 08/2015. After perusal of the complaint on the CR case numbers 08/2015, and also after examination of the complainant and the complainant's witnesses under section 220 and 202 CRPC, respectively, wide an order dated 6/10/2015, the learned CJM directed the officer in charge, SEPA police station to register an FIR, and accordingly, SEPA PS case number 113/2015 was registered against the petitioner. The aforesaid SEPA PS case number 113/2015 was registered under section 409/420/471/468/34 of Indian Penal Code. Next, after completion of the investigation in SEPA PS case, the investigating officer submitted the charge sheet by CS charge sheet number 15/2016 against the petitioner under sections 409, 420, 468, 471, and 34 of IPC. After submission of the charge sheet, the petitioner duly appeared before the learned CGM SEPA Mr. Charge was framed. Charge hearing happened.
No,
Huh?
no. During charge
Charge
hearing, my lord, they filed the petition, my lord. During charge hearing,
At the time of charge hearing, what happened? Because it says
they filed a petition for
during the charge
transfer.
hearing. Okay.
Yes.
Okay. Duly appeared before the court, collecting necessary copies of the case records. Full stop. However, during the framing of the charge, during the hearing of the framing of the charge,
Vigilance filed a petition, my lord.
of the charge, the superintendent of police, SIC vigilance in bracket, Itanagar, filed an application white letter dated 18/8/2016 before the CGM SEPA, requesting that the case file be transferred. Praying for transferring of the case file to SIC in bracket vigilance Itanagar. It is seen from the aforesaid application of SIC that the prayer was basically made due to the fact that the petitioner, being an active public servant who was facing allegations of corruption and therefore the provisions of PC Act 1988 would be applicable in the instant case. On receipt of the application from the SIC in bracket vigilance, while in order dated 11/11/2016, the learned CGM SEPA, after hearing both the parties, directed that the entire case record be transmitted to the Superintendent of Police SIC in bracket vigilance Itanagar for further investigation and submission of charge sheet under the relevant provisions of PC Act before the learned special judge, UPR. On such transmission, the ACB submitted a fresh charge sheet, white charge sheet number 01/2025 under section 409 IPC read with section 13(2) of the PC Act 1988 on 28/1/2025. Against the petitioner. Thereafter, the learned special judge UPR, in exercise of powers under the PC Act 1988, registered the matter as case number 1/2025, wide order dated 23/6/2025, taking cognizance against the petitioner and thereby formally initiating the criminal proceeding against the petitioner. The 23/6 order is not there. Mr. Bora, that order is not there.
No, my lord. Not at-
23/6 order.
No.
Next para, being aggrieved with the aforesaid order dated 23/6 2025. But you have challenged this order also, right, Mr. Bora? 23/6?
Not in the cost title, my lord. That is not in the cost title, my lord.
But it is not, I mean, that order is not annexed.
Not in the cost title, my lord.
No, I mean, where is that order? 23/6?
We have not annexed, my lord.
Why? But that has been challenged by you, isn't it? That, I mean, that cognizance also.
No, we have not impugned, my lord.
Sorry?
We have not
We haven't
impugned that order, my lord. We have not challenged that
We have-
order, my lord.
Why that the cognizance has been taken by that order only, by special court? Why that was not challenged?
Well, we have challenged the charge sheet and the initial order, my lord.
You have challenged the charge sheet, but
Yes.
on the basis of the charge sheet, that cognizance was taken,
Yes, my lord, that's true, my lord.
and cognizance is taken, and process was issued under by this order
Yes,
only.
Because we have challenged the, my lord, the initial taking of the complaint case and the subsequent sending of that, we are aggrieved by basically, my lord. Then thereafter, the consequence of the charge sheet, my lord. That subsequent
But what
cognizance is-
happens? But what happens if if that order stays?
my lord, if the
If
charge
you-
sheet is
if you-
stayed, my lordship is staying the charge sheet, my lord, then there is no consequence of that trial, my lord. That's what we have challenged the charge sheet, because charge sheet has come up because of the magistrate order to file the charge sheet under the PC Act, which he doesn't have the jurisdiction. That's why we have challenged the charge sheet, my lord.
So I mean, you are basically saying that, I mean, since this is subsequent order of charge
Yes,
sheet,
madam.
so if
Yes,
charge
madam.
sheet goes, the order is invalid.
Yes, madam.
When is the next date fixed?
9th of May,
Huh?
sorry, March. 9 March.
9th of March, yes. So by that order only 9th March is fixed, right?
Probably,
But somewhere it has been stated, I think.
there are 17.
Para?
17.
No, not 17. Before that, somewhere it has been stated that it has been fixed on 26. Ravi,
Cognizance order.
we have written somewhere no, that where is he? See where?
Paragraph 3, my lord, last line,
Paragraph 3.
last line.
Yes.
For consideration.
yes. Correct. That's what I was looking. So what was the license? 25. Fixing 932026 for consideration of charge. This the petitioner has filed the instant petition challenging the legality of the aforesaid order, along with the aforesaid order of taking cognizance, aforesaid order dated 23/6/2025, as well as the impugned order dated 6/10/2015, passed in CR case number 8/2025 by the Learned Chief Judicial Magistrate, SEPA. and the impugn order dated 11/11/2016 passed in GR case number 127/2015 arising out of SEPA PS case number 113/2015 passed by the learned Chief Judicial Magistrate SEPA, whereby the entire case was whereby the entire case was transferred for further investigation to ACB Itanagar. Full stop. Full stop. Mr. A.M. Bora, the learned senior counsel, appearing for the petitioner, submits that since a departmental inquiry as well as an administrative proceeding which culminated in a report, culminated in a detailed report dated 18/9/2025, has already been submitted. A consequent submission, a consequent lodging of complaint case is not warranted as the same amounts to undue harassment of the petitioner as well as duplication of inquiry. Full stop. He further submits that the order dated 6/10/2015, whereby the learned CJM SEPA, in exercise of powers under section 156 in bracket 3, whereby the officer in charge of SEPA police station was directed to register an FIR is bad in law, which is procedurally flawed and without any jurisdiction.
As my lord, already witnesses has been examined.
Now he submits that the aforesaid order is bad because the learned CJM, prior to the aforesaid order, has taken cognizance of the matter by applying his judicial mind recorded the statements of the witnesses and considered the documentary materials. Now considered the materials, documentary materials available before the court. Therefore, he submits that once cognizance has been taken and statements of witnesses have been considered as considered and documents have been perused by the learned CGM. The further direction of inquiry by officer in charge Sepa police station was not called for. He further submits that learned CGM had in fact found materials under section 409 stroke 420 471 468 of IPC and having found materials of offenses under the aforementioned sections, the learned Chief Judicial Magistrate has gone beyond his jurisdiction and beyond his jurisdiction by invoking section 156(3), which gives a very limited scope to the magistrate after exercise of magistrate's power under section 200/202 CRPC for taking cognizance. Full stop. Therefore, he submits that the aforesaid action of the Chief Judicial Magistrate is very much incorrect under the very much incorrect as per the provisions of the statute, as well as the ratios laid down by Honorable Apex Court in many cases. The learned senior counsel submits that after appearance of the petitioner before the Chief Judicial Magistrate, subsequent to the filing of the charge sheet number 15/2016 of SEPA case number 113 of 2015, and as he was facing the trial and facing the trial, in fact the hearing, when the hearing was going on for framing of charge, the transfer of the case, the transfer of the entire case to the Anti-Corruption Bureau, in bracket ACB, by his order dated 11/11/2016 for further investigation and filing of charge sheet under PC Act is totally uncalled for, which is unlawful and beyond the jurisdictional powers of a magistrate. He further submits that it is only a special court constituted under Section 3 of PC Act has the jurisdiction to add add the PC Act, add the PC Act, or direct any proceeding stroke inquiry stroke investigation under the provisions of the PC Act. PC Act. And therefore, by order dated 11/11/2026, the learned CGM has traveled beyond the power which has been conferred upon him by relevant statute. In view of the aforesaid submissions, in view of the aforesaid primary and basic submissions, amongst others, the learned senior counsel submits that the entire process that has been conducted before the learned CJM SEPA is illegal as the same are beyond the jurisdiction which has been given to him by the concerned statute. In view of the aforesaid, he submits that the entire proceedings which started from the filing of the complaint case till the submission of the charge sheet by the ACB, and consequent orders dated 23/6/2025 by the special judge UPR should be set aside and quashed. Full stop. That's all, Mr. Bora, or any more submissions to be recorded? Mr. Bora, anything else?
No, my lord, no, my lord.
This is fine. I mean, your submissions are that only, right?
Yes, madam.
To that effect. Next pair. On the other hand, I will refer to your cases. I will refer to your cases. I'll refer to your cases. 1 second. In support of his submission, next para, in support of his submission, the learned senior counsel has referred to the case of Devarapalli Lakshmi Narayana Reddy and others versus V. Narayana Reddy and others, reported in 1976, 3 SCC 252. Wherein the Honorable Supreme Apex Court has clarified the issue regarding taking cognizance of an offense. Full stop. The Apex Court in the Apex Court in that case has held that on receiving of a complaint, the magistrate applies his mind for purposes of proceeding under section 200. 200 and proceeding and 200 and succeeding sections of chapter 15 of the code. He is said to have taken cognizance of offense within the meaning of section 190 in bracket 1 in bracket small a. Small a. Make a subpara. Mr. Bora, the learned senior counsel, Learned Senior Counsel submits that in the instant case on hand, by recording the statements of the witnesses as well as by perusing the documents, the learned CJM has already taken cognizance of the matter. The Learned Senior Counsel has also referred to the case of Sampatlal Jain versus State of Assam, reported in 1991 to GLR 445.
There are 22, my lord.
Yes, yes. Wherein the Guwahati High Court has held that adding of sections under PC Act could be done only by a designated court, and not by any other criminal court. Full stop. In view of the aforesaid, the Learned Senior Counsel submits that in the instant case, as the Learned CJM SEPA is directed for investigation under the PC Act, the same is not as per the ratio laid down by the Honorable Guwahati High Court in the instant case. Is it so, Mr. Bora?
My lord.
Another case you have referred to, I mean, that
2011 to GLT
2011 to GLT.
610.
Learned Senior Counsel has also referred to the case of Rana Sinha versus Rana Sinha alias Sujit Sinha versus the state of Tripura and others, reported in 2011 to GLT 610.
Yes. Variety for those.
Yes, yes.
Paragraph 80 is more important, my lord.
80.
My lord, 80. Placitum C.
Hmm?
My lord, when
Paragraph
around the 10th
80.
time, paragraph 80. Once the cognizance has been taken,
wherein the Honorable, wherein the Guwahati High Court has held that the act of proceeding with examination of the complainant under section 200 will be indicative of the fact that the magistrate has taken cognizance of the offense and has decided to proceed accordingly. It was further held in the case that once he decides to hold, no, this hold that it is it is held that when the magistrate, after recording the statement of the complainant and his witnesses, if any, decides to hold inquiry under section 202 of the code, he cannot thereafter send for investigation a complaint which discloses commission of offense, which is, one second, which is exclusively triable by a court of session. The act of sending complaint for investigation after recording of the statement of the complainant and or witnesses and or after holding inquiry under 202 of the code is a stage which may be called the post-cognizance stage. So in view of the above, the learned senior counsel submits that in the instant case, as the witness, as the complainant and witnesses have already been examined, it is apparent that cognizance has been taken by the learned CJM's court, by the learned CJM SEPA. Thereafter, without remitting the matter to the special court, he could not have added the PC Act in the instant case. Mr. Bora, is it okay? I mean, this is your submission, right? This is your submission, correct? Can you tell me if your submission is not properly recorded? I think this is your submission. Your voice is not coming, it's mute probably.
Yes, my lord.
But this is all your submission, right?
More or less, yes, man. This is my submission that once he has taken cognizance, he cannot go to 156.3, man.
Yes. So full stop. On the other hand, the Mr. Opada, the learned special public prosecutor, ACB submits that there is no violation of any statutory provisions of CRPC the CRPC involved in this case. He submits that the learned Chief Judicial Magistrate SEPA has all the powers to further direct for investigation in the instant case. So you state about the, power under 170
173 and 150,
173
173,
and 176.
156.
Sorry, 156. 156, 3, right?
Yes.
1 second. One 173, which subsection?
8, my lord.
Hmm?
8.
8,
Yes.
further investigation.
He submits that the magistrate, the concerned magistrate, has ample power under section 173(8) of CRPC, read with section 156(3), to direct for further investigation in the matter. He submits that by he submits that during the trial, more specifically during the hearing of framing of charge on an application filed by the ACB Vigilance, right?
Earlier it was, my lord, SIC. Now,
SIC Vigilance.
yes, ma'am.
Stroke ACB, you can write.
My lord.
Stroke ACB, the learned Chief Judicial Magistrate has directed the matter to be transmitted to the ACB, to the ACB for investigation under the PC Act. PC Act on 11/11/2016 is not violative of any provisions under the CRPC, as the power has already been given under section 176(8). 173(8) of CRPC. Full stop. In support of his argument, therefore he submits that there is no violation in the instant case by directing for the investigation under PC Act by the learned CGM SEPA. In support of his argument, he referred to the case of Binu Bhai, Hari Bhai, Malviya and others versus State of Gujarat and another, reported in 2019 17 SCC 1, wherein which para specifically you want to refer to
Para
for this agreement?
25.
Because there are so many
Yes, yes, my lord.
para
25, my lord.
25.
And para 28 was relevant, my lord. 28 and 31.
25 or 28?
25.
The 28, 28, okay.
29 is in regard to, my lord, that even after taking cognizance, the magistrate has the power to direct for further investigation. Two aspects, my lord.
Wherein the Honorable Apex Court has held that the magistrate's power under section 156(3) CRPC is very wide. Wide, very wide, and very wide, which includes ordering of further investigation after a report is received by him under sections 173(2). It is further held in the case that the power would continue with the magistrate at all stages of criminal proceedings until the trial commences. That will do.
Well,
So in view of the aforesaid ratio laid down by the Honorable Apex Court, the learned special counsel submits that since the magistrate has ample power for directing further investigation by police, in the instant case, no violation has been committed by the learned CJM in directing further investigation by the ACB. Further investigation under the PC Act having found materials against the petitioner under the PC Act. That will do. Full stop. This court has heard
my objection to the interim order may be required.
in view of the aforesaid, then you write, so learned special public prosecutor therefore opposes any interim order granted by opposes any interim order that is prayed for by the learned counsel for the petitioner, learned senior counsel for the petitioner. This court has gone through the materials brought before this court, heard the submissions made by the respective counsels appearing for the parties, as well as perused and examined, as well as perused the ratios laid down by the Honorable Apex Court as well as Guwahati High Court in the aforementioned cases. This court without going into much in depth in the instant case, this court having found that the order that the order whereby the order dated order dated 11/11/2016 passed by the learned CJM SEPA, whereby the entire case was transferred for further investigation by Anti-Corruption Bureau in bracket ACB Itanagar by himself, rather than transmitting the matter to the appropriate court, that is the Special Judges Court. Special Judges Court is prima facie not as per the law laid down by the Honorable Apex Courts, laid down by the Honorable Apex Court. This court is of the considered view that though this court has found certain prima facie, this court has found prima facie materials for materials. No, what was written? Considered opinion that having found this prima facie material to be considered in the instant case is of the opinion that at this stage notice should go to the respondent number 2 and 3 at this stage. That notice should go to the respondents at this stage for further consideration of the matter. Full stop. Therefore, it is directed that notice is to be issued to respondent number 2 and 3 by way of speed post, returnable within 4 weeks, returnable within 4 weeks, full stop. Notice to respondent number 1 is dispensed with as the learned special PP ACB has put in his appearance in the matter. As for the interim, this court is of the prima facie view that there are materials for further consideration in the matter. Therefore, in the interim, it is directed that the further proceedings pending before the learned special judge UPA in connection with special case number 1/2025 shall be stayed until further orders of this court. A registry to call for TCR in connection with the special case number 1/2025 from the Court of Learned Special Judge in bracket Prevention of Corruption Act, 1988 UPA.
The scan copy. The scan copy.
Scan copies of the TCR UPA. Let the matter be listed in the last week of January.
After 4 weeks.
After 4 weeks.
Yes.
4 weeks till last week of January.
What line knows service support respondent number 2 speed post with ID card.
A speed post is always with ID card only. Speed post means it's registered. It will be there.
With ID card. Name will be reflected, madam. It does not reflect me.
Your name is there. Yeah, I've written. Initially, I have written.
No. In the post list.
Oh, cause list. Okay, you're asking about the cause list. Registered to reflect the name of Mr. O. Para, the learned special public prosecutor appearing for the appealing for the state respondent.
My lord, deeply obliged.
Obliged. Deeply obliged.
Item number 9.
May I please, ma'am? This application is for, my lord, indulgence, of course, in someone's liberty. That is for cancellation of bail.
Then this matter has to be heard properly. I mean, it will take some time.
My lord,
Cancellation of bail will take some time.
basically, I am saying, my lord, this order is perverse, my lord. It's because,
Then you'll have to go, or if order is perverse, then you'll have to go for setting aside of the order rather than cancellation.
my lord,
There are two things.
two things.
One is setting aside of the order of bail and another one is cancellation of bail. Though the effect may be almost same,
My lord,
but for cancellation of bail, there are different conditions has to be measured.
my lord,
Parameters are different. And for setting aside of the order, if it is perverse, you are saying the setting aside of the order, I mean, then there are different these parameters.
my lord.
So are you aware of those? I mean, like, have you, because see, cancellation of bail happens only when there is a
violation of.
there is a violation of the conditions, right? But order or setting aside of the order is if the order is perverse, order is passed without jurisdiction,
Non-application of.
or non-application of mine, order is against the statute, something like that.
My lord.
So in your case, what is the case?
In my case, we are saying that this impugned order is perverse, my lord. Yes, because there was completely non-application of mine. The circumstances, my lord, even while granting the bail, my lord, the learned JMFC, my lord, UPA, has,
So you have come for setting aside and crossing of the impugned regular bail order.
my lord,
Here, private respondent was also implicated. Private respondent,
So he's not there today.
yes,
it's not there.
he is implicated.
Earlier appeared.
So we'll have to fix a date for this. I mean, when do you want it?
That case, my lord. 22 जरा सामने जनवरी में. Sixth January, my lord.
Okay, on the joint prayer of the council appearing for the parties, let the matter be fixed in the month of, fixed on 6th of January, 2026.
Lordship, it's a holiday, 6th. 6th is
6th is
holiday,
holiday.
Lordship. 7th.
Oh, 6th is holiday. So 7th of January.
7.
Oh, you are not available. Then fix it on 19th of January,
19 January, my lord.
19th January.
Obliged.
19th January.
Highly obliged.
Item number 10.
What is the matter?
This
for what?
An appeal,
Huh?
appeal against the conviction.
It will take some time. Today may not be possible.
This is a conviction is wrong. That is why I have filed IA for
correct,
suspension
but I
of the
think that-
sentence law.
But it may not be possible. Yeah.
Your Lordship, this is the first time the matter has come. Your Lordship can.
Oh, first time.
Yes, Your Lordship.
Where? Item number?
Item number 10.
Oh, it has come for the first time.
Yes, this is on motion.
So disposal will take some time. That's what I was worried about. So you have filed an IA?
Yes.
What is the IA?
IA is for suspension of the sentence law. Sir.
And under which section?
There is no.
No, under which section?
It is actually 376 ref, but there is no frame, no these charges under 511 and 400. Kindly see, kindly see that this order, conviction order.
One second.
Conviction order is case number.
1 second. No, we'll do one thing. We'll issue notice on this because
Matter may be admitted, Lordship, and
no, we'll admit this.
matter may be admitted, and this issue notice over the IA for
It is a statutory appeal.
hearing.
This certificate.
Hearing over this interim order on the next.
That then we'll issue notice on that.
Yes. On interim, this on IA notice may be issued and.
No, IA notice has to be issued.
Yes.
Correct. I mean, there's 376 is involved. 376
376 is involved, but not convicted on 376 laws.
convicted on
311, 511.
511.
Yes. Attempt to rape.
But you have made a party, no? I mean, that
Yes.
victim.
Yes.
So notice has to go.
Yes.
Heard Mr. T. Tapak, right?
Yes.
T. Tapak, the learned counsel appearing for the appellant in a appeal, you write. Appellant. Also heard Mr. T. Gini, the learned APP for the state. This is an appeal.
Against conviction.
This is an appeal under section 415 to BNSS, assailing the judgment dated 13/10/2025 and sentence order dated 21/10/2025, passed in Consa Sessions Case number 12/2024 under section 376 and its corresponding. But 376 is there.
Yes, 376 is there, but during the trial it was there. But the conviction has been.
Right, the
The
conviction is under
what?
376,
The court could not
511.
convict. Court
Okay,
could not
okay.
convict under 376, saying that it is.
Corresponding Longding PS case number 7/2024 under section 376/354/354A/448/34 of Indian Penal Code, read with section 3 of SC and SP Act.
No,
That was,
Hmm.
that is the search sheet.
no, your lordship.
Sir,
No, one second.
As per the search.
Conviction is only under
Only on
Only
500.
376, 511 and 354A.
376.
From the cost title,
507.
it's not clear, Mr. Tapak.
Yes,
It's at
507.
page number 57, your lordship will find.
Conviction is on.
One second. Then I'll have to go to this
Yeah.
order.
Start
Con-
with page number
Page number
56
57.
and the relevant portion is at page number 57. Second paragraph.
$376 is there.
Yes, it's there. Read with it's 511. 511.
Correct, 370, you are saying 370 is not there.
Yes, 376.
Sentence order dated 21/10/2025. Whereby the appellant is convicted and directed to undergo a sentence of 10 years rigorous imprisonment for offense under section 376/511 IPC with a fine of rupees 10,000 and 3 years simple imprisonment for offense under section 354A IPC with fine of rupees 5,000 to be paid to the state exchequer through e-grass challan, in default, the convict shall serve another period of 6 months in custody and the sentences shall run concurrently. Admit the appeal, issue notice to respondent number 2 through speed post.
Throw PP. Maybe.
Okay, throw PP. Issue notice on respondent number 2 through the registry in terms of the prevailing notification number 27 issued by the Guwahati High Court. The steps shall be taken within a period of 3 days from passing of this order. Notice on respondent number 1 is dispensed with as the learned APP has put in her appearance in the case. Registry to call for the TCR in connection with concept sessions case number 12/2024 from the court of
Sessions Court Concern.
Sessions Court Concern. Sessions Court Concern. Full stop. Let the matter be listed after 4 weeks.
2 weeks, 3 weeks. After 3 weeks.
After 3 weeks.
Yes.
After 3 weeks. In the IA, you write both the names, so and so, Mr. Tapak, T. Tapak.
Like the hearing over IA.
Mr. T. Tapak, the learned counsel appearing for the applicant. Also, Ms. T. Jini, the learned APP for the state. This is an application under section 431 of BNSS for BNSS 2023 for suspension of sentence and grant of bail to the appellate convict against impugned judgment dated 13/10/2025 and sentence order dated 21/10/2025 passed by the learned session judge Khonsa in Khonsa Sessions case number 12/2024 under section 376 and
511 and 354A.
376, 511 and 354A. You write all those sections, Mr. Tapak, in Costatal. I mean, if you half write it, I mean, if you not write those proper sections, then it will be there. I mean, you should write all the sections. Okay, so and so. Under sections, you have written 376, 511 and 554 of the IPC. IPC. Issue notice to respondent number 2. Respondent number 2 through the registry in terms of notification. You have written that so and so, so and so. We are within 3 days steps. Then CD is already called for, then let the matter be fixed after 3 weeks. Okay.
Item number 12.
This
is a bail application under section 483 of BNSS, my lord.
Yes.
Praying for the release of the accused person, my lord, was arrested on 13/9/2025.
1 second.
Last occasion, TCR was called for, but it was
TCR is not received.
TCR was for.
My lord,
Without TCR, it will be difficult. Miss.
otherwise, my lord, charge sheet has been filed.
Correct, but then you appear before the, I mean,
My lord, 2 bail applications were moved before the trial, my lord. Both have been rejected.
but now since the charge sheet, after charge sheet, you have.
Charge sheet also, 1 application was moved. That has been also.
Then TCR has to be perused.
My lord, apart from that, one ground I have raised, my lord, non-furnishing of the ground of arrest, my lord. This apart from TCR of the merit of the case, my lord. If my lord can look into that aspect.
Which aspect? What was the ground?
My lord, non-furnishing of the ground of arrest. My lord, there's no.
No, so non-furnishing of the ground of arrest could be ascertained only when the TCR is there.
Well, in the arrest memo itself, my lord.
No, that's what like we'll have to look into the arrest memo. The arrest memo will be available before the TCR with the TCR only.
And my lord, in the bail rejection order itself, my lord, the learned trial court has also reflected.
No, those things will not. This court has to go through the TCR. I mean, we'll have to ascertain whether. I mean, that may be a ground. That may be a ground for consideration, but that has to be looked into.
Considering my lord, this bail application.
And then we'll put it some other time. I mean, maybe in the 22nd or something like that. 23rd.
Some urgency more than my lord 90 days. He has already been in the custody, my lord.
So it's a charge sheeted case. 90 days is, I mean, Charge sheet already been filed. 90 days doesn't matter now.
But then may pray my lord on this because 20 to 15. My lord, can it be on 16 or 17, my lord?
Hmm?
17,
17.
my lord.
We'll fix it on 17 if PCR comes. I mean, heard, Mr. You are Mr. R. Sonar. R. Sonar, the learned counsel appearing for the accused applicant. Also heard Mr. G. Tado, the learned APP for the state. TCR in the instant case which was called for is yet to be received. Let the matter be fixed on 17th of December for further consideration. For further consideration. Registry to send a reminder for requisition of the TCR in the instant matter.
It's the second time, my lord, today.
So we have directed for one listing.
Develop.
Item number 13.
आता तो बेल ऑर्डर की वो कुछ नहीं खाली डिसीजन आज दल बदला दिए नहीं हां मैं सब भी तो दियो बोलेगा मुझे ना ये लागत है बोलेगा ना बेल ऑर्डर में yes
Lordship, on 8, report was sought for Lordship. Wherein Lordship, it appears after 82 days.
The case record is there.
Yes.
Huh?
Yes, Lordship.
Case record is you have received.
Yes, Lordship.
Yes, what is that?
Lordship, till that I didn't submit the charge sheet since he.
Charge sheet has not been submitted.
Yes, Lordship.
And he's in this thing for.
He is overstayed, Lordship. Purely submitting, Lordship.
Oh, then
Yes.
so then we'll get a default bail.
Yes, yeah, Lordship. This is.
I'm just excuse me for 5 minutes. I'll come back.
Okay.
5 minutes. I'll pass down. 5 minutes. Yes, heard, Mr.
Yes, Lordship. This accused person is.
No, your name.
Yes, he coming.
Tamil Nadu Learned Counsel appearing for the accused applicant. Also heard Mr. L.
D. Loy.
Huh?
D. Loy.
D. Loy. Mr. D. Loy, Learned PP for the state. This is an application under section 483 of BNSS, praying 2023, praying for release of the accused applicant on bail in connection with Dumpo Rizzo Police Station, case number 16 of 2025 under section 21 in bracket small b of NDPS Act 1985, read with section 3 in bracket 5 BNS 2023. The instant application has been filed on behalf of the accused applicant, the accused Kokomara, right?
Yes, Kokomara.
Accused Kokomara by being authorized by for accused Kokomara by now, who is accused? Accused is Kokomara.
Yes.
And it's filed by whom?
This filed by Majemara.
Hmm?
Majemara.
Majemara is who?
He is the brother, this family brother of the accused person.
filed by Majay Mara,
Yes, Lordship.
filed by Majay Majay, huh? Majay Mara, on behalf of, being authorized by Coco Mara, Coco Mara, the accused person. The gist of the fact, as has been alleged in the FIR dated 16/9/2025, is that on receipt of certain confidential information about confidential information on 15/9/2025 about storing of certain narcotic drugs at the residence of Coco Mara of Bello village, the police team proceeded to the residence of the accused person and from the house of the accused person, that is Coco Mara, 78 vials containing suspected heroin weighing 7.8 grams, 8 grams in bracket without vials was recovered. Accordingly, on receipt of the FIR, accordingly Dumpo Reserve Police Station case number 16/2025 under the aforementioned sections was registered against the accused person, and the accused person was arrested on the same date, that is on 16/9/2025.
Yes, Lord.
16/2025. Since then, the accused person is behind the bars for how many days?
As of today, Lordship, it is 85 days.
Behind the bars for last 85
Yeah.
days. 85 days, full stop.
Lordship, our case is pending due to the non-receipt of FSL report.
No, whatever. 85 days. It is the learned counsel appearing for the accused applicant submits that though the person is arrested more than 85 days back and behind the bars, no charge sheet has been filed in the instant case as yet. Therefore, he submits that the accused since the narcotic drugs that has been alleged to be recovered from his place is of intermediate quantity, he should be released on bail. He should be released on default bail. Full stop. The learned public prosecutor has submitted that in the instant case, the charge sheet is yet to be filed. Full stop. Yet to be filed, and therefore the accused person is liable to be released on default bail. Full stop. This court has gone through the materials brought before this court, and on the basis of the submission made by the learned counsels appearing for the respective parties is of the opinion that since he has already spent more than 60 days behind the bars, he is liable to be released on default bail at this stage. Accordingly, it is directed that the accused person shall be released on bail on furnishing of a bail bond of rupees 50,000 with a security of like nature to the satisfaction of.
This family, this father is alone in the is also is a sick person, and
NDPS matter.
Lordship, this also one.
Okay, we'll make it 30,000. We'll 30,000.
Lordship, one more accused in this item number 150.
No, 30,000 with, heroin you have has been recovered. 30,000.
Lordship, kindly 20,000 for both accused. Kindly.
How many people are there?
Yes, 2 accused. One more accused is in this bail.
Item number
No. Huh?
item number 14 or so.
Yes.
Same.
Accused.
Okay, 20,000 with a security of like nature, subject to the following conditions. You put those NDPS conditions. to the satisfaction of which court?
Yes, this is Basel. Additional this
Huh?
special court.
Huh?
It's special court Basel.
To the satisfaction of special court Basel.
Yes.
Special court Basel, subject to the following conditions, put those conditions in view of the aforesaid direction. The instant bail application is disposed of as allowed.
Developers.
Same order in
Item number 14. The accused is Beller is applicant is Tatumbara and the accused is Pajanmara.
okay,
Same case.
same order that only the names will be changed. Yes.
Item number 15.
Developers.
May I please, your lordship?
Yes.
Lordship, this is a pre-arrest bail application, lordship. Last occasion, the interim was granted, lordship. I have appeared before the police station also, lordship. I have given my statement also, lordship. CD was called for.
Yes, Ginny.
Yes, we have just submitted the CD, Your Lordship. Lordship, otherwise also in this matter, the applicant here is cooperating with the investigation, Your Lordship.
So we'll make it absolute.
Yes. No objection to that.
Obliged, lordship.
Heard, Mr.
J. Ginny, lordship.
Mr. J. Ginny, the learned counsel appearing for the accused applicant. Also heard Ms. T. Ginny, the learned APP for the state. This is an application filed under section 482 of BNSS 2023. Praying for pre-arrest bail in connection with Itanagar Police Station case number 74/2025 registered under sections 85/61 in bracket 2 bracket small a stroke 117 bracket 2 of BNS 2023. Full stop. The gist of the allegation as narrated in the FIR dated 6/11/2023 is that the informant therein lodged an FIR before the officer in charge Omen Police Station, Itanagar, alleging domestic violence, mental and physical harassment, assault, assault, causing grievous hurt, cruelty, criminal conspiracy, attempt to murder, or threats to life, word, gesture or act intended to insult the modesty of a woman, criminal intimidation and other serious offenses against the informant's husband. It was also alleged that the husband of the informant, that is the accused applicant, is maintaining illicit relationship Who is the applicant?
Applicant is
Lordship,
Karpi River, the
Karpi River,
allegation,
Huh?
the allegation against which there is an allegation of having an illegitimate relationship with the husband of the complainant.
Okay. Illicit relationship with the present applicant by present applicant. Present as an applicant, and both her husband and the present applicant conspired to kill and eliminate her. Full stop. On receipt of the FIR, the police, the police authorities have registered Itanagar Women PS case number 74/2025 under the aforementioned sections. While in order dated 18/11/2025, a coordinate bench of this court has granted interim pre-arrest bail to the accused applicant, Full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid order dated 18/11/2025, the accused applicant has already appeared before the investigating authority and got her statement recorded. Full stop. The learned APP and got her statement recorded. He further submits that in view of her appearance before the IO and cooperation with the investigating authority, this court should make the interim order so passed earlier absolute. Full stop. He submits that the accused applicant in the event of her bail application being allowed shall participate and cooperate with the investigating authority. Full stop. The learned APT, Mr. T. Gini, the learned APP, appearing on behalf of the state, submits that the accused applicant has already appeared before the investigating authority and cooperating with the investigation. Therefore, she doesn't opposes the prayer of the accused applicant at this stage. Full stop. On consideration of the aforesaid submissions, as well as on perusal of the materials brought before this court is of the opinion that the interim PRS bail so granted by the order dated 18/11/2025 should be made absolute. Full stop. Accordingly, the instant bail application, instant PRS bail application is allowed by making the interim order dated 18/11/2025 absolute with the same terms and conditions as put in the aforesaid order dated 18/11/2025. In view of the aforesaid directions, the instant anticipatory bail application is disposed of as allowed.
Obliged.
Matter number 17.
Yes.
Your service is not complete because there is a private respondent.
Okay. Heard. MS. Your name?
Tirini.
Kirini, the learned counsel appearing for the petitioner, also heard.
G.
Mr. G. Tado, the learned APP for the state. APP for the state.
And also, petitioner is supposed to file additional affidavit.
Your Lordship.
The office note dated the learned APP appearing for the state submits that the service on respondent number 2 is yet to be completed. He further submits that
Office note.
not completed, you just keep it like that. Completed the office note dated 10/12/2025 further reveals that affidavit to be filed by the petitioner. Additional affidavit to be filed by the petitioner.
Your Lordship, I was supposed to file an additional affidavit
Additional affidavit for what?
in connection with this for the call of TCR.
Hmm.
Since the TCR has been already been received, so I may be dispensed with this additional affidavit.
But there is no order of filing it. Anyways, you write the office note dated 10/12/2025 reveals that an additional affidavit to be filed by the petitioner is yet to be filed. However, the learned counsel appearing for the petitioner submits that since the TCR in the instant case has already been received, there is no requirement of filing any additional affidavit in the instant case. Therefore, she submits that she should be dispensed with from filing with the additional affidavit.
Yes.
Affidavit. In view of the aforesaid submission, this court dispenses with the filing, and this court directs the filing of additional affidavit by petitioner should be dispensed with. Let the matter be listed after the ensuing vacation.
Your Lordship, I have a submission, Your Lordship. This criminal petition is pending since 2024, Your Lordship.
2024, yes.
Yes, Your Lordship. And respondent number 2 has not been appearing, Your Lordship. So, Your Lordship, I'm praying for hearing. On that.
Then have you taken steps, proper steps?
Long back.
But then you take fresh steps.
Yes.
But without, I mean, this is a POXO matter, right? It's
No,
what-
no,
what-
no, no,
no.
no, Your
what-
Lordship.
This
It's
is a matter of
325/392 IPC.
392, Your Lordship, IPC.
Grievous hurt and robbery. Interfering with the construction of Hydel, power Hydel.
So it says that address is not correct. Have you given the proper address?
Yes, yes, Lord.
Can you verify it? Can I verify it? And if required, you take a fresh steps.
I will take.
Because there is no report has come, no report has come. And without, I mean, it becomes difficult for the court to without
Without
hearing the other side to pass any order, correct? You take a fresh steps, you verify the address and take a fresh steps, and we'll put the case sometime in the month of January. So that by the time you take the steps, and if you take proper steps, then you will see that whether it can be, it can be done without when any deemed notice or something like that.
Yes, yes, Lordship. Yes. Your Lordship, matter may be
The learned counsel appearing for the petitioner is directed to take fresh steps in the instant case after proper verification of the address of the respondent. Steps to be taken within 3 days from passing of this order. On the respondent number 2, respondent number 2, and steps to be taken within 3 days of the order
yes, Your Lordship.
by speed post.
Okay, yes.
By speed post.
Your Lordship, the next the next date may be fixed after winter vacation, Your Lordship.
That's what I mean. First week of January.
Yes, yes.
Let the matter be fixed in the first week of any date.
Before from January 1 to 8, any date.
On 8th January. Let the matter be fixed on 8th January.
Obliged.
Obliged.
Matter number 18.
Lordship, I'm appearing for the petitioner.
No.
The second is yet to file affidavit.
No, Your Lordship, we are supposed to file an additional affidavit in opposition, but we will not file the affidavit in opposition. So
When are you going to file it?
no, we will not file, Your Lordship.
We are not filing, but you
Yes.
have stated you will be filing it.
Yes, we are supposed to file, but we are not filing. So matter may be fixed for hearing, Your Lordship.
You are Mr. You are Mr.
I'm B. Padu.
B. Jamo.
Padu.
We are the learned counsel appearing for the appears for the petitioner. Heard Mr. So-and-so for petitioner. Also heard MS.
TDB.
TDB learned counsel appearing for the respondent. You are respondent number 2.
Sole respondent.
Sole respondent. For the sole respondent. The learned counsel appearing for the respondent submits that C is not going to file any affidavit in the instant matter, and hence the matter should be posted for hearing. So affidavit is not required.
Not required, Your Lordship. Not required, Lordship.
Not required.
Yes.
Why? If you do not file any affidavit, then all the, allegations against you will be termed as correct allegations. If you do not rebut it.
We'll just, we'll argue that directly, Your Lordship.
Argue on the basis of what? Without any affidavit. See, if you do not rebut their allegations, then the allegations will be termed as correct. On the basis of that, court will proceed. What are the allegations?
We're challenging the cognizance taken under 138 NI. The entire proceeding.
130 NI.
Yes, cognizance was taken.
Okay, then, this is, I think she'll argue on law points only. Then it will fine.
Interim may be continued.
The matter may be fixed on so interim order so passed earlier shall continue till the next date of listing.
Please.
Matter number 19.
Yes, yes.
I'm for the petitioner here.
Hmm.
This is a POCSO matter.
Notice, received.
Service upon lordship, victim not completed lordship.
Office note dated 10/12/2025 reveals that service on respondent number 2
Lordship,
is yet to be completed.
Lordship, I have received the service copy and I'm representing a victim, Lordship.
We come this side. Then you write heard, Mr.
T. Sering.
He's selling the learned counsel appearing for the appellant. Also heard Mr. D. Loy, the learned public prosecutor for the state, as well as Mr.
T. Kyamdo, Lordship.
So, the learned counsel appearing for the respondent number 2.
2, ma'am.
Respondent number 2. Let the matter be fixed on
My
when.
Lord, I have a humble prayer, my Lord. Since the parties are duly represented, I filed on IA, praying for suspension of the.
So that will be considered the next that he is appearing today only. Let the matter be fixed on when?
First week of January, my Lord.
First week of January. You let him prepare the matter.
My lord.
Just appear for the.
Matter
Are you
number 20.
prepared? Are you prepared to argue the matter?
Yes.
Today you're prepared. We'll hear you on the first week of January.
My Lord. Oblige, my Lord.
Matter number 20.
My lord, this matter is at the motion stage, but wrongly put in the order category, madam.
What is to be done now?
So now my case is that, my lord, I have filed civil revision petition against a Kaba decision, my lord. My lord, herein the Gamboda Association has passed the decisions in regard to a land dispute, my lord.
But this is come in the order column. What is to be done?
So,
We'll put it up in the next week.
my lord,
In
then
the
it will
motion
put
column.
tomorrow, my lord.
Tomorrow, will it possible? It is wrongly listed.
Possible.
Okay, we'll put it tomorrow then.
Oblige.
The learned counsel, Mr.
K.
So appearing for the petitioner submits that the matter has been wrongly listed in the orders column, where instead of motion column. Let the matter be fixed tomorrow at under motion column.
Matter number 21.
Your oblige.
Yes.
Joint application.
Hmm?
Joint application.
Hmm.
Paying for passing of case number 57.
What is the offense?
The petitioner.
What is the offense?
118 subclause to corresponding with 326 of IPC.
What is that? I don't remember. Clauses.
Previous.
Previous heard.
Yes.
Previous heard. What has happened?
The petitioner number 1 is the complainant who was the higher level
of petitioner number 2. He
Mm.
was working under the
Mm.
construction work. And on 28th, there was on 28th June 2025, there was some scuffle, some argument, heated argument. They went on, and both of them, they had pushing and pulling. They fell down. The petitioner number 1 received some injury, and subsequently they settled the matter, and they are now living harmoniously and working under him only still. So subsequently they have settled the matter, and during the even executed joint agreement settlement.
Agreement, where is that?
Page 1990 and except 3.
Page 19. Yes, Mr. Loy.
Lordship, since this is settlement, Lordship,
Hmm.
both the party entered into Lordship.
Hmm.
I have no objection, but the Lordship on the last occasion, updated sheet was called for, but we didn't receive. But I leave it to Lordship since.
Okay, we'll pass the close it. I mean, small issue.
Yes, Lordship.
Small issue.
Yes.
Heard Mr.
Queen.
Queen, the learned counsel appearing for the petitioners. Also heard Mr. D. Loy, the learned public prosecutor for the state. The instant application. Instant application has been filed jointly by the petitioners under section 528 of BNSS 2023, praying for quashing of Doimuk PS case number 87/25 under section 118 in bracket 2 of BNS 2023, corresponding to GR case number 536 of 2025, arising out of FIR dated 28/6/2025. Full stop. On receipt of the FIR, the police. Any charge sheet is filed? No. On the receipt of the FIR, the police has registered the Doimuk PS case number 87/2025 against whom? Against petitioner number 2.
Against, yes.
Against petitioner number 2. Against the petitioner number 2. Full stop. The gist of the allegation, as has been narrated in the FIR dated 28/6/2025, is that the petitioner number 2 engaged petitioner number 1 as a construction worker in the construction of a building at Lower Emchi village under Doimuk circle. On 28/6/2025, it was alleged that petitioner number 1, who was working as a construction worker, along with some other workers, wanted to leaving certain work at the site. Full stop. At the site, full stop. When the petitioner number 1 requested them to complete the work and thereafter go, the petitioner number 2 got involved with some verbal altercation, and thereafter a scuffle. Thereafter a scuffle occurred between the petitioner number 1 and petitioner number 2, whereby the petitioner number 2 fell down on the ground and got sustained.
Petitioner number 1.
Petitioner number 1 fell down and sustained some minor injuries. Full stop. We have stated about the registration of the case? No. Stated? No, I haven't said. Uh-huh. No, there's okay. And the learned counsel appearing for the petitioners submit that though the FIR was filed against the accused, against the petitioner number one, right? Against the petitioner number one by the petitioner number two, looking into the entire issue, and with the help of his friends and relatives, both the accused number one and accused number two have come to a mutual agreement whereby the petitioner number two wishes not to go ahead, not to pursue ahead with the case which has been filed against the accused, against the petitioner number one.
Petition number two.
Sorry, no, who has filed the FIR?
Petition number one.
Petitioner number one.
Petitioner number one.
Is the complainant.
Petitioner number one fell down, right? I agree, petitioner number one. Not to go ahead with the, not to go ahead and pursue the case filed by the petitioner number one. Accordingly, a mutual settlement agreement has been executed by petitioner number one and two on
28 July
28 July 2025, wherein it has been specifically stated that the petitioner number one and petitioner number two have mutually agreed to resolve all differences and discords between them pertaining to FIR dated 28/6/2025, which resulted in registration of Doimuk PS case number 87/25 under section 118 in bracket 2 BNS 2023. It was also agreed by the parties that parties shall maintain cordial relationship between the two and refrain from making any further allegations, claims, or other accusations against each other in respect of the said incident. The accused number two has further agreed to not press and pursue the case pertaining to Doimuk PS case number 87/2025 and shall withdraw the same with all interest and purpose, as the same has been amicably settled and resolved by both the parties. It was also agreed by the parties in the aforesaid settlement agreement that though the offense under the FIR is non-compoundable, the parties shall jointly file an application before the Honorable Guwahati High Court for quashing the Doimuk PS case number 87/2025. It was further stated in the settlement agreement that both the parties have executed the mutual settlement agreement without any force or coercion, and as per their own sweet will. In view of the learned counsel appearing for the petitioner submits that in view of the aforesaid agreement and and wishes of the parties to close the Doimuk PS case number so and case number so and so. What is the case so and so? This court may quash the FIR, quash the concerned FIR, in terms of the ratios laid down by the Honorable Apex Court in various cases, in non-compoundable offenses also. The learned, Mr. Loy, learned, D. Loy, learned counsel, learned public prosecutor, has submitted that in view of the mutual settlement agreement, and taking into account the issue involved, taking into account the allegation involved in the instant case, the instant case, this case can be closed at this stage.
Yes, sir.
Closed at this stage. Full stop. I'll give you some paragraphs in between. Then write one paragraph. In view of the opposite discussions and after consideration of the submissions made by the learned counsel for respective parties, as well as the materials available on record, and taking into account the principles laid down by the Honorable Apex Court in the aforesaid cases, this court is the considered opinion that ends of justice would be served if both, if the FIR, dated 28/6/2025 and 25 corresponding to Doimuk PS case number, Doimuk PS case number
88.7.
Doimuk PS case number 87/25 is justice would be served if the instant petition is allowed by quashing and setting aside the FIR dated 28/6/2025 corresponding to Doimuk PS case number 87/25. Full stop. Next para. In view of the aforesaid finding, the instant criminal petition is allowed by quashing the aforesaid FIR dated 28/6/2025 and the Doimuk PS case number 87/2025. Accordingly, the instant petition is disposed of.
Deeply.
From here, you take it. Some paragraphs from here. Paragraph 18 to 24. 18 to 20. Para 18 to 24.
Item number 22.
Lordship, in item number 22, the IS for condemnation of delay of 75 days, Your Lordship. On earlier occasion, the respondent had taken time to file their affidavit
Hmm.
objecting, Your Lordship, but I have just been informed by Mr. K. Lawlen, who is the counsel for the respondent, that they won't be filing any objection, Your Lordship.
No objection.
Third, Mr. J. Ginny, the learned, T. Ginny, the learned counsel appearing for the. This is what matter?
This is
Civil revision.
civil revision.
Ginny, the learned counsel appearing for the petitioner applicant. Also heard, Ms.
I'm sorry.
Joy, the learned counsel appearing for the respondent number,
The sole respondent.
sole respondent. And then this is petitioners, petitioners, applicants, sorry, applicants. Applicants, this is an application under section 5 of Limitation Act 1963, praying for condemnation of delay of 75 days in filing the connected civil revision petition, full stop. Full stop.
Your Lordship, I have stated my ground in paragraph 13, 14, 15, 16, and 18, Your Lordship.
Okay. 13?
13 to 18, Your Lordship.
13 to 18, okay. In the instant matter, the learned counsel appearing for the respondent, though earlier sought time for filing an objection. However, today today before the court, she submits that she is not filing any objection, and she doesn't have any objection. She is not filing any objection in the instant matter, and she doesn't have any objection.
Your Lordship, kindly list the main revision petition after one way.
Sorry?
List the main revision petition, Your Lordship.
Correct. I mean, this has to be disposed of, correct? You don't have any objection, right?
No, no objection.
And she doesn't have any objection in condoning the delay of 75 days in filing the connected civil revision petition. This court has considered the submission made by the learned counsel appearing for the respondent, as well as the grounds mentioned in paragraph 13 to 18 of the instant application. After consideration of the submissions as well as the grounds mentioned in the aforesaid paragraphs in the instant application, this court is convinced that sufficient explanation for condemnation of delay has been made out by the petitioner, and therefore the delay of 75 days is condoned. Is condoned. Full stop. Accordingly, the instant application for condemnation of delay is disposed of. Full stop. The registry to register the civil revision petition and accordingly place the same for place the same for admission, right?
Yes, Your Lordship.
Place the same for admission after the ensuing
Puja vacation.
answer. After no puja is there.
After one.
Where is puja? After the ensuing vacation.
After winter vacation.
After the
Meantime, the copy of the petition could be.
Meantime, the extra copies. No, notice to no.
Lordship, on the day when the matter is.
When the material come, they will give you, because it has to be registered. Then only they'll give you.
Yep.
Let it be registered, then only give you. Well, notice will be issued in this main case, then it will be given to you.
Yep. Online.
Matter number 23.
I think.
No time today.
Time.
So we'll fix it when after vacation.
Your friend also was there for the other party. I think tomorrow is not possible.
Tomorrow hearing will not be possible. Tomorrow Friday.
Then also on 22nd.
22nd or after the vacation. The other side is also not there.
Otherwise, on 22nd.
Let the matter be fixed on 18, 19 then. No, 19th. 19 we'll see what can be done.
I think that's possible.
Then the first week of January.
Then they can.
Heard Mr.
S. Tapin was.
S.
S. Tapin.
S. Tapil.
Also, Tapin.
Tapin. Okay. Heard Mr. S. Tapin in the learned counsel appearing for the petitioner. None appeared for the respondent when the matter was called for. Let the matter be fixed in the first week of January.
Loss.
First week of January for hearing.
Loss. Outlines.
Item number 24.
Came up for hearing on several occasions, my lord, owing to paucity of time, my lord, this always happens.
We'll fix it for some other time when.
Yes.
Subject to convenience on the part of the counsel for the petitioner, my lord. Otherwise, I'm ready, my lord. It is a small matter, my lord.
You are appearing for whom?
Respondents, my lord. Private respondents.
How many are there? Total?
Three numbers, my lord. Two petitioners and 3 respondents, my lord.
Others are not, you are appearing for whom? To
All the
all the respondents.
Yes, my
I am for the text.
Huh?
I am for the text.
You are for the appellant.
Yes.
No, you are for the petitioner.
lord. Petitioner, my lord.
Then we'll fix it in January or what?
After 2 weeks, Lordship.
So in the month of January, first week.
Yes.
First week. Heard Mr.
Elbam.
Elvam, the learned counsel appearing for the petitioner. Also heard Mr. K. Tato, no, T. Kato.
M. Kato.
Sorry, M. Kato, the learned, I'm new, so a little bit a little familiar.
My lord, I'm for the
M. Kato, the learned counsel appearing for all the respondents. On the joint prayer, let the matter be fixed in the month of first week in the first week of January.
my lord.
Finish
Finish, Lordship.